Mary, is Christy here? Christy ready to go?
Yeah, I was going to introduce her.
Okay.
Is that okay?
Yeah, Mary Cagle will introduce her.
Can I introduce your first witness? Is that okay? Yeah. I just kind of wanted you to understand who she is. So, just, you know, I don't really want to do it.
What did I do? Yeah, I stopped over at Diana.
Ladies and gentlemen, let's get started, and let's get right to it. Mary Cagle, will you get us started?
Yes, I will.
Overview here.
Thank you, sir. Good morning. Your first witness is Christy Lopez Acevedo. And she, at the time, she was an attorney with the Guardian Ad Litem program. She started with the Guardian Ad Litem program in August of 2006. So from your timeline, you can get a feel for where in the course of the case that is. And she works for the Guardian Ad Litem program until September of 2007, at which point she leaves. And in April of 2008, she comes to work for Children's Legal Services with the department. So just to kind of give you the context, I mean, today she works for CLS, but at the time of the events, she was the lawyer for the Guardian Ad Litem program. Okay? Christy.
Good morning.
Good morning.
Should I just start from the beginning? Okay. In August of 2006, when I started with the Guardian Ad Litem program, I was assigned to Division 9 before Judge Butchko. At that time, Division 9 was a newly created division. I want to say sometime in early 2007, the division had been created. The way that Division 9 got cases at the beginning was other divisions took from their caseload and moved them over to Division 9. The reason I say this is because the case was before Judge Venzer before it was before Judge Butchko. So it went from Division 3 to Division 9. When I get the case is in TPR posture. The mother's rights had been terminated, the biological mother of Nubia and Victor, and the biological father, Victor Bustillo's rights had not been terminated as of yet. From August to November, not much happens on the case for me. I was just told as I was staffing and learning my caseload that this was a TPR that was coming up. There was a parallel state attorney criminal case going on that the kids were testifying in that case as well. So we were still collecting some of the evidence, and the basis of the TPR petition were sexual abuse allegations that had come up as to the children once they had been placed in the foster home of the Barajonas, as to the father, Victor Bustillo. In November of 2007, we were going to go to the TPR, and we asked for a continuance. The children, we needed the ability to testify reports, and the trial gets set sometime in February. February of 2000, that was November 2006. February of 2007, we start the TPR trial before the backup judge, Judge Edelstein. At this point, Judge Butchko has left to criminal court, and Judge Valerie Mano-Shore is now the judge presiding over the case. We do a child hearsay motion to get their testimony in. We actually end up having to do it twice, and that delays the TPR trial from February all the way through April. That's why it took so long. It was about a 2 to 3 day trial.
You have a timeline right now. You haven't got all the... I'm following. I'm actually taking notes. But,
Okay. I don't have anything physical except my handwritten notes. That's okay.
just go a little bit...
A little bit slow? Okay. Not a problem. Okay. So the father's TPR trial as to the biological father is from February 2007 through the final judgment is entered May of 2007. It was a 2 to 3 day trial. It was before Judge Edelstein, and Victor and Nubia testified at that trial. During that trial, at the end of March 2007, I cannot give you a specific date because I just don't remember, I get a call at 5:30 p.m. from the principal of their school at Blue Lakes Elementary, Mrs. Ada Marrero. Principals of schools don't normally call at 5:30 in the evening to the guardian program attorney. So when she told me who she was, my reaction was, what must be going on for a principal, teachers might call her principal, to call me? She was extremely concerned about the children, and she informed me that the school would be calling in an abuse report as to Victor and Nubia. The reasons were there had been certain incidences that concerned them, such as Nubia one day had applesauce in her hair in the afternoon. When she came to school the next morning, the applesauce was still there. She was missing school on Wednesdays, and she was missing language arts, which took up 2 hours of the end of the day. And that was one of the subjects that she was having difficulty in. There were approximately 14 times that she had been pulled out of school early.
You were told that by the principal?
By the principal, correct.
At that time of that call?
Exactly. She also informs me that there's unexcused absences. Although there were medical appointments, there were unexcused absences. She tells me that Nubia is hoarding food. Tells me that she's packing up whatever she can during lunch and sticking them in her backpack. And what really, really, I think, made it even more disturbing was when she tells me that Nubia is petrified of the foster mother. That Nubia's reactions when they inform the child that they're going to be calling the foster mother, the child becomes hysterical. I don't remember the details of the conversation with the principal as to what I said she should do or not do. I cannot tell you that. But I do remember saying, go ahead and call in the abuse report, and we're going to look into it ourselves. I specifically remember, she also told me that that the guardian nor the case manager had gone out to the school, which kind of was a little surprising. So I needed to investigate that a little bit more. So I spoke with the guardian supervisor, Miss Klein at the time, and I said, I need to find out if the guardian's been going to the school. And at the time, Paul Newman. Hey, at the time, Paul had not gone out to the school, and I told the guardian supervisor, get Paul out to the school ASAP. He needs to be going out to the school. He needs to see what's going on. He needs to go talk to the teachers. And Paul immediately responded and did just that. The principal also tells me that there's a concern that we should speak to the teachers from the previous school the children were at, Royal Palm Elementary. She says the children had only been at Royal Palm Elementary for like 2 to 3 months, a short period, and that their belief was that the children were pulled from that school when the teachers started complaining about potential neglect or concerns over the foster parents. This is the principal telling me. It's still a conversation with the principal. Yeah. Since we were in the middle of a trial, I spoke with the DCF attorney who was handling the TPR trial, Michelle Austin. Said, we've got an abuse report calling in. We discussed what to do, and we decided that we were going to inform Judge Edelstein, the TPR backup judge, that there was a potential that an abuse report was being called in. There were concerns as to the placement. We did not know what the investigation was going to result in, But we wanted to be candid with the court and let him know that there was this issue in case when we got to the disposition after the TPR, if in fact the TPR was granted, that there might be a placement issue.
This is during the trial in March 7.
Correct.
And Victor Nubia testified.
Yes.
In that courtroom, is the foster mother there?
Yes. And I had interactions with them.
Foster dad there?
Yes.
So both of their opponents are there during that time?
Yes.
While these children are testifying?
They weren't in the room while testifying. They were outside waiting. They brought the children to the courtroom. We had them via closed-circuit TV. Victor, can't remember who went first, honestly, but I think it was Nubia. Nubia testified, and then Victor testified, or vice versa. And while we had one child in the room, the foster parents were waiting with the other child outside.
And could not hear the testimony?
No, because the testimony was being seen inside the courtroom for the father via closed-circuit TV, and the child, we didn't want the child in there watching the testimony, so they were outside in the hallway. It was on 73rd West Flagler. That's where the trial took place.
Maybe I got this confused. To some degree, this trial is about the natural father's potential sexual abuse.
Correct.
Now you've got a new starter in here, which is allegations about the foster parents, maybe particularly the mother here? Is that what
Both.
you're telling us?
No, both. We didn't know. We didn't know. I kept saying the foster mom because she's the one that would go to the school to pick up Nubia and Victor and deal with the school, but we didn't know. It could have been either one.
So the trial is, in theory, has nothing to do with the foster parents.
Right.
But suddenly there's this entry and you feel obliged to make sure the court knows this.
Absolutely, because when you at the end of a TPR trial, you ask the judge to dispo, or the disposition of the case. You ask the judge to dispo the children to foster care, to relative care, and one of the things a guardian testifies to is the placement of the children, the recommendation of the TPR, and whether there's a pre-adoptive home. So I had a guardian who was going to be testifying. Children have been there for an extensive period of time. This is a pre-adoptive home. They can be adopted. I had to let the court know that there was an abuse report that after he testified, I may come back at dispo and say, get those kids out of there. I mean, it didn't make sense not to tell the court.
Absolutely.
Had to tell them.
When you're preparing the children to testify, who's examining the children?
I did.
You met with them ahead of time?
Yes. Yes.
And you did that, when you did that, who was present?
Okay. I really didn't, and I tried not to ask them the questions when I met them because it was my first meeting with them. And if I remember, the foster parents were present and the guardian was present. I don't remember who else was present, and I can't even tell you what day I did it or where I did it. If it was at the juvenile justice courthouse or at the guardian office, I really don't remember. But I did meet with them to say, and the reason where I remember, it may have been even right before the hearing, was to introduce myself so they would know that I was the one that was going to be asking them questions.
And when you're, the testimony that's elicited from these children
Yes.
is detrimental to their biological father?
Yes, it is, absolutely. Nubia's testimony was.
And obviously the foster parents would know.
Oh, yes, it was the foster mom who was seeing Nubia's alleged sexualization, sexual reactions, and there's concern, and it starts coming out that the father, the biological father, had sexually abused both of the children.
So in terms of motive,
Okay.
the Barajonas, it's in their interest to have the little girl testify against their biological father to the effect that it will actually separate that time so that there will be a need to find them a permanent home.
That can be one way to look at it. Yes. They were okay. They were very supportive of the children testifying, and the kids had been interviewed quite a bit. And when we get to the evidentiary hearing that we had with them as to the placement, Mrs. Barahona spoke about the stressful nature and everything these children endured, from the CAC interviews to the state attorney interviews to our interviews, and how just their life was filled with these stresses due to all this testimony they had. And Nubia was an excellent witness. I remember Judge Edelstein's findings, and I've never forgotten them. And I reread the transcript, and they were there, that Nubia's 6-year-old's testimony to the detail was so impactful that the TPR was granted. Victor's testimony was neither here nor there. And we didn't expect Victor to give us a lot of testimony because he hadn't been as forthcoming. But Nubia was so consistent, and she was great. She was a great witness.
I guess what I'm going with, and maybe I'm just saying too many things, is was her testimony such that she's living at the time she's a witness, she's living with about a month.
Yes.
I'm just wondering whether or not Barahona influenced her testimony.
Well, thinking back now, I question that. How can I not? I mean, I have a little girl who is so specific, and I'm thinking, well, was she coached? Was she not? At the time, there was no reason to believe she was. Looking back, I have a lot of questions. I really do. Okay. So in May, the TPR is granted. I'm sorry, the TPR is granted before, but the order is signed by the judge sometime in May. May 29th, I want to say, was a date that I looked back to see the final judgment being executed. In May of 2007. In our next hearing before Judge Manoshore is June 8th, 2007. And I went ahead and I've listened to the recordings from this hearing because it was quite a while ago and I don't remember all the detail. And so I've got my notes, and that's what I'll be looking at. That's what I wanted to let you know, okay? Can't remember everything. Okay. We go before Judge Manoshore because the father, the biological father, asks for appellate counsel. And he has to come before the court, fill out his indigency form, and a new procedure had been put in at that time. And he comes before the court. When we're at the hearing...
This is to appeal that judgment?
Yes.
And he's asking, I can't afford an attorney?
Correct. Yeah. Because he had just gotten out of jail. He got out of jail, and he came before, and he had some medical issues, and he says, I have no money, I have nothing, I want to appeal, I want my children back. So he has to fill out the paperwork. So we are there for appointment of appellate counsel. Since we had these other issues, we told the judge a hearing has already been set. We would like to discuss some other issues with you on the case. The department is present. I'm present, representing the Guardian Ad Litem program. CFCE Courts Liaison is present, as well as defense attorney Steve Grossbard. He is there because since there was this information that there might be an issue with the appropriateness of the placement, the aunt and uncle from Texas called him to come to court to say, if something's going on, we want custody. So those were the people present during this hearing on June 8th. The father wants to be present for everything. We ask the court to, once we're done with the appellate component of it, for him to leave because he has no standing any longer as his rights have been terminated. So the biological father was not there for this entire hearing. He was outside. At the time I filed a motion for the court to review the appropriateness of the placement. And I emphatically told the court that the motion was not to remove the children from the foster home, but to review the appropriateness of the placement, because we had 2 expert psychologists telling us that it was detrimental harm to remove these children from the foster parents.
As a matter of general theory, or as a matter of practice, this is a particular
As for this specific case, as to Victor and Nubia, we would destroy their capability to bond to adults if we pulled them from their home. Dr. Archer was one of the psychologists, and then Dr. DiTommaso followed up with the same response after he evaluated the children for their ability to testify.
Are they here today?
They declined. They were invited, but they declined.
Okay.
Do you know whether or not they spoke to the teachers, the principal?
No, because from their evaluations were prior to my conversation with Ms. Marrero, the principal of the school.
So their recommendations are being considered at a time after those calls are made by the school.
Correct.
But is without the benefit of the information from the school.
Correct. I'm not a psychologist, nor do I claim to be. So we went by what their recommendations. They are the experts.
And is the father essentially saying the previous judgment was wrong? I never touched this child.
Oh, absolutely. The entire time, the father is making a claim that there is no way he touched either one of them. But I'd have to go back and pull like his arrest form and everything. But I believe he was in prison for some sort of sexual issues with a neighbor, a young girl. So put two and two together. Does it to a neighbor and his child? It wasn't shocking that Nubia was saying this. It wasn't at the time. But he always contended that he had not touched them inappropriately or done anything to them.
Chris, I'm sorry. This is very... The Archer, and I don't mean to cast aspersions, they're not here.
Absolutely.
They may be completely justified in what they did, but Archer and DiTommaso are two psychologists.
Yes, they are. They're two psychologists. They're experts that we used in the case as our expert, witnesses.
And their recommendations are considered by the judge. In this case, is it Judge Edelstein or Judge?
By all the judges.
Okay. So their recommendations are considered at the different stages of the proceedings.
Absolutely.
But what kind of mechanism is there in place to ensure that they are recommending based upon those current facts available?
That's a really good question. Usually when we get these evaluations, and now I'm going to tell you just in general, I'm not going to talk about Victor and Nubia per se. Usually when we get these evaluations, we get them, let's say, on a specific date for a purpose. We get the children evaluated. Dr. DiTommaso was specifically for an ability to testify as to the children. We get that evaluation. That's an evaluation we have. We don't say in 6 months, let's get it reevaluated and check. Things have changed unless there's specific circumstances that call for that. Reading some of the stuff, so it wasn't. That was the evaluation was there. And we stick to it. And when you read the evaluation, you're being told it's detrimental harm to move these children out of the home because of their bonding. That doesn't seem like that's likely going to change in a year. That issue is still going to be there if there's nothing, no imminent risk of danger to these children. That makes sense what I'm saying.
How do you insert the information you gathered in this proceeding? The school information.
I file a motion. I file a motion to review the appropriateness of the placement.
Based upon that information?
Based upon that information. That's all I've got. I've only got the information from the school.
So you file that in
June 8th of 2007.
And what happens to that information? Is that
Okay.
heard?
Oh, absolutely. I'll move on to the evidentiary hearing. But I want to finish your question because there is some notes in my review that we did want Dr. Archer to reevaluate the children. Dr. Archer or Dr. DiTommaso, I cannot remember right now which one. And we were told it's too soon to do another evaluation. One was recently done. And one recently been done the previous year. One of the two doctors, and I can't remember which one. So sometimes we'll ask for evaluations and we'll be told, no, it's too soon. We just did one 3 or 4 months ago or even a year ago. It's too soon to do another one.
Too soon because
They were just evaluated.
Now,
They had been evaluated.
the call from the teacher was in March?
Yes, March of 2007.
Okay. And, right, the principal, was it March of '07. Well, there was a follow-up call by teachers to the hotline, right? In addition to the principal.
Yeah, I don't know who the actual reporter was. I don't remember.
And this hearing that you're having now is in June.
Right.
And the evaluation by the doctors was at what date?
I don't remember Dr. Archer's evaluation date. I want to say Dr. DiTomaso's was sometime November 2006, around that time, because it was around the trial, was the ability to testify. So I filed a motion to review the appropriateness of the placement, and I informed the court that I had received a call. What I just told you, that I received the call and what the principal had told me, I specifically told the court. I told the court that, unfortunately, the school was not willing to write a report, that the school principal had called the previous school principal, so Blue Lakes Elementary principal speaking to Royal Palm Elementary principal, so because the principals are concerned about the children, they had conversations, that the guardian, Paul Newman, had met with the principal and the teachers, and again, I informed the court that we don't want to pull, due to the psychologist saying detrimental, to pull the children. But we do have an alternative, the aunt and the uncle in Texas, if the court were so inclined to then decide to move the children.
And the school did not want to file a report.
No.
Because?
I don't know if that's part of their policy and procedure, but they were not willing to put it on paper. So the only way, they were willing to come in and testify, so the only way I could get the information to the court was via testimony.
But the school did call you, the principal called you.
Right.
We're not sure yet. We'll double check. The teachers may have also called the hotline.
Right.
I think the law, as of that point in time, that's all that they were required to do as mandatory responders.
Right. I wanted a written report so I could get it into, to the judge, but they weren't willing to do that. So the only way that I could get the information was via testimony.
And did you say that they were willing to testify?
Yes. Yes. And that's going to come next. That's coming. That's coming. I don't want to miss any of the details. I want you to understand the process. Okay. We did inform the judge, the department informed the judge that the issue of the aunt and uncle had already been litigated before Judge Venzer. This was before my time. I was not present during that or those hearings, but a decision had been made by Judge Venzer that the children were to remain with the Barajonas and not go to the aunt and uncle in Texas. Again, I believe the basis of that decision was Dr. Archer's report, or one of the bases.
There's also a pediatrician in addition to these two psychologists, right?
There are pediatric reports and medical reports as to the children.
On the timeline, I see, and I apologize for bothering you.
It's okay.
On the timeline, June 6, 07, it says pediatrician submits letter.
Correct.
So, you know when?
Is that June 29th, 07? June 07?
According to the timeline I have, it's June 06, 07.
Right. There's a letter that the Miller School of Medicine, Dr. Sanchez, writes to CFCE, I am assuming since it's Mrs. Jacobo, about Nubia's issues, and that what the letter says is that she has adult body odor due to her issues, that it's normal for her to have, it's not neglect, and also that due to her medication she can want to overeat, and we have to be careful about her overeating because of potential obesity. That's what the doctor was saying. Nubia at the time, I remember her. She was really tiny and very
This is the doctor
small.
that endorses the mother's care.
Yes, yes,
Sanchez with the Miller School of Medicine.
correct. A pediatric endocrinologist. So again, we have psychologists and medical professionals, and I have to report that to the court.
You don't know whether Dr. Sanchez spoke to the teachers on it.
No, I do not know that. Okay. At the same time, when we filed the motion for the appropriateness of the placement, I informed the court that the foster parents have complained about the guardian, Paul Newman, and that they are forbidding him from coming to the home. That was extremely concerning to us because, one, by court order, the guardian is to go to the home, and they had left a message to the guardian supervisor that Paul Newman was not allowed to come to their home. So,
Assumes that's a very rare instance?
Though in the when we get to the evidentiary hearing, I had forgotten there had been this voicemail message about, he is not allowed to come to our home. Yes, usually there's some resistance, but not to the extent of you are not allowed to come to our home. What we decided to do at that point was say, okay, Paul, go to the school, see the children at school until we have this evidentiary hearing. Why make the things difficult for the children in the home? So that's what we had decided to do. But
Any questions about his conduct at all in your mind?
no, absolutely not.
So as far as you know, he's a first-rate guardian.
Absolutely, because I saw him interacting with the children. I saw them when he was in the room during the testimony and I remember he was sitting next to me and the child was next to him. They loved him. I saw the interaction. There was no reason to think that Paul had been inappropriate. Never had there been a complaint about Paul. I had talked to him on a regular basis, and there was no reason it was more like, what's going on that they don't want us to see?
So as good as a relationship as you saw in this whole case was Mr. Newman and these children, what you're saying essentially at this moment, let's get through the hearing and then we'll get this resolved afterwards. Just go to the school and wherever else.
Exactly.
For these moments.
Right, and then you also think, well, maybe they think, we're obviously it was that issue of, they think we're causing all these problems on purpose. Let's just keep going to the school and see what the court decides. But we kept telling the court, he's got to go to the home, and the court kept saying, no, he has to go to the home. Foster parents, you have to allow him in the home, but they still wouldn't. And you'll get more details of that in a few minutes.
And you're going to take us to the point where he is taken out of this situation?
What do you mean taken out?
At one point, is he not removed from...
But that was after I left the Guardian program, so I will not be able to specify as to when or how he was taken out.
Chris, this is about the same time the parents were writing to the governor, too, because there was 2 or 3 communications they had with the governor complaining.
The foster parents? Yes. 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 And it's mentioned in the evidentiary hearing. Okay. Let me see. Let's see. So the guardian's going to school, and we asked the judge that we need a hearing date so that the principal and the teachers can come to the court and testify. So the next date is set for June 29th, June 29th, 2007. At the same time, we are due for a permanency hearing and a case plan. The court liaison, Ms. Andre, with CFC, requests that the day of the evidentiary hearing, we also do the permanency and case plan to not be out of compliance. There's no objection to that. And we're set for June 29th. There was also information given to the court that the guardian ad litem had visited Texas, the aunt and uncle in Texas. He happened to have been on a business trip at some point and went to their home, was saying that if there needed to be a change in placement, this would be a recommended placement. There was also some information that the Barajonas took that as we were trying to side with the Texas, the aunt and uncle in Texas. We did inform the court that it was very premature for the aunt and uncle to be coming to these hearings. Their attorney, Mr. Grossbard, was trying to get them to be there for the evidentiary hearing. And we just informed, we're not going to, object to this right now, but it is kind of premature. This is just information that the court needs to hear. But the court was fine with them appearing via phone just to hear what was going on. Now, the judge at that hearing states to the parties, Judge Manor Shore, at the end, says, I know that the foster parents have had Nubia and Victor a long time, and I also know that they've previously adopted children. She was very specific to say that she had met the foster parents prior and that she was the judge who signed off on a prior adoption. And she said, I just want to know what's going on. Maybe there's possible services that need to be in place to assist the foster parents and the children. There have been many stresses in this home, and we want to try to do whatever we can to save the placement. She then went on to tell us about a child who had been adopted, that they had adopted, that had been with them since birth for 3 years, and a relative, after 3 years of placement with the Barajonas, had come out of the woodworks, for lack of a better word, and stated that they wanted custody of the child. And the judge presiding in that case gave those relatives the child, and the child was moved to another state. It was so horrific for the child that the relatives brought the child back to the Barajonas, because that's where the child really needed to be, and that this family had been through a lot.
So we're now hearing, in the judge's words, what she believes to be a parallel.
Correct.
Not
Correct.
taking the kids around.
And then the department also responds by saying that Dr. DiTomaso and Archer said it would be devastating to move these children, and that this, again, had been litigated before Judge Venzor. And I informed the court that the guardian was not doing this in any possible way to cause problems. We just needed to know what was going on. Something was going on, and we needed to know what it was.
Where's the principal's testimony figured in there?
Okay. The next hearing is set for June 29th, 2007. I come before the court, and I ask the court because the principal had not shown up that day for the subpoena, that I wanted to withdraw the motion, because without the principal's testimony, I had nothing. It was hearsay. It was hearsay on hearsay on hearsay, and I needed the principal present. The principal, there had been a complete miscommunication with the principal. The department had subpoenaed the principal. The principal had left a message that she was not available on the date of the hearing. The phone call was not returned until the morning of the hearing. The principal was off for the day, and I had been informed that the principal was unavailable to testify, and I came before the court and said, we cannot have a hearing if I don't have the principal. The judge was fuming that the principal had not abided by the subpoena and had not shown up to court. We went on and back and forth trying to get the principal on the phone. The principal then appeared on the phone, said that she tried to communicate that she wasn't going to be there, but if another date was given, she would definitely abide by the subpoena. She was given the date of August the 3rd for the evidentiary hearing. At this hearing, it's not too long, but I want to let you know that the aunt and uncle came from Texas. They were present. The foster parents were present as well. The judge did not grant the motion to withdraw because she was very concerned about the well-being of the children and really wanted to hear from the principal, as we all did. So she said that she needed to have the evidentiary hearing. The foster mother discussed, there were some questions about the children's absences with the foster mother. She said it was only a couple of times because during early release days because of the other child from school. Sorry. Let's see. Let me just see what. Okay, they discussed a lot about.
You know that's wrong, right?
Correct.
To believe the principal at
Right.
all.
And that will come out. The judge, again, states that she knows these custodians, but she needs to know what's going on. Let's see. So in that hearing, the judge resets the case, and we are set then for the evidentiary hearing where the foster parents where the principal testifies. Again, in that hearing, there was a talk about the guardian being against the foster parents, that the guardian wanted the children to go to Texas because he had visited the home. We continued to say that that wasn't the issue. It was that we needed to know what was going on because of the concerns of the school.
So this is August 2007?
That is July 29th, 07.
When does the principal testify?
August...
July 29th.
I'm sorry, let me go back. I have it here written. June 29th, 07. I apologize.
So far, we haven't talked about.
No, that's August 3rd. That's the next hearing. I just wanted to make sure there was nothing else that was missing here. The agency.
Give us a point in time.
This is that same June 29th hearing. That we informed the Guardian program informed the court that it wasn't until the principal called that everything started. The Guardian was not against the foster parents, that they cannot continue to forbid the Guardian to go to the home. I informed the court that Your Honor had told the foster parents that the Guardian was to go to the home. The Guardian had yet to be able to go into the home. The agency did inform the court that there were issues with the children, that Victor had speech problems, and that the school was supposed to have been looking into this. DCF told the court that since the Guardian had made the agency and the department aware of some of the issues from the principal, that CFC had been going out to the home more often. Unexpected visitors, licensing had gotten involved to make sure that this was a properly licensed foster home. The agency did report that the children were fine. Again, that this doesn't have to do with the relatives in Texas, and the judge says the relatives will only come into play if we move the children. And again, the aunt and uncle request visitation with Victor and Nubia. We object to the visitation, again, based on Dr. DiTomaso's report that say the children should not see any relatives. The attorney for the aunt and uncle makes a claim that the reports may say that, but the doctors never met the aunt and uncle, so it's not fair to do that to relatives who haven't been met by these experts, but the judge says no visits for now. Okay.
These are the relatives of the father, right?
Correct. It's the paternal aunt. I believe she's the sister of the father. Okay. Let's go to the evidentiary hearing.
We're in August now?
August 3rd, 2007. The department is present. The guardian ad litem is present. I am present. CFCE is present. The case manager is present, as well as the foster parents are present. The biological father shows up, saying that he wants to know what's going on. We tell him he has no standing. He's removed from the courtroom, and we proceed with the evidentiary hearing.
And just so that it's clear, this is an evidentiary hearing on your motion for the court to review the appropriateness of the placement.
Yes. Yes. I informed the court that the guardian ad litem program is not asking the court to change the placement. I informed the court that I had received a call at 5:30 p.m. with an abuse report having grave concerns over the children, that there had never been a problem. Paul Newman was a guardian for this case for well over 2 years, 3 years, I believe he had been on the case. I informed the court that, as I spoke already, that the school principal is calling at 5:30. That's not something that happens every day. So we started our own internal investigation. There were 3 total abuse reports that had been closed. We needed to know why these children had failed the first grade. At this time, school's over. It's the summer. They failed the first grade. Why the school's calling in reports. That's my quote unquote opening to the court as to why we're having this evidentiary hearing.
This is all set forth in a written motion.
This is all. Yeah, I haven't actually seen the motion in quite some time, so I can't remember what it was actually in it. Since I don't, it's the Guardian Program's motion. But I'm assuming I put certain facts in there or allegations. Again, we filed a report that the foster parents still hadn't allowed the guardian in the home to see the children. Now we're in August. I had said it in May, and by August we still haven't been in the home.
And the calls were in
Exactly.
30 p.m. calls in March.
Yes, it's been over 3 the foster parents, when the state that the guardian had never been out to the home, would never go out to the home very often, which of course is not true, that he had to set up appointments to see the children, and Paul Newman said that was incorrect. He stated that during the time between May and August, he had received he had left a message for the foster parents, I want to come see the children. The foster father had then called him, left a voice message saying, it's 7:50 p.m., you can see them at 8 p.m. He's like, that's unrealistic for you to tell me that I got to take off and go and within 10 minutes be there to see the children. And then there was another voicemail where he said, you can come between 8 and, you need to come in the morning and see them before noontime. He set up a time with them at 10 a.m. When he got to the home, there was like a sticky note or a note on the door that said, we're out back, knock hard, yell for us. He said he did, and he was not able to see the children. The foster father later testifies that he was out back and just couldn't hear the knocking, but he and the children were waiting for Paul. So the judge says, I don't like this. I don't like games in my courtroom. That's what you're doing, the foster parents, and we need to get to the bottom of this. The department went to question the foster parents further. The judge said, not now. We're going to go ahead and start the hearing, the official evidentiary hearing. The first witness was the principal. Let's see. Ada Marrero testified. Okay. She testified that, and I'm just going to go through my notes and just obviously interrupt me, so I'm just going to go through my notes. Yeah. Okay. Testifies that there was an abuse report that had been called in, that the teacher of the children came to speak to her, that they were concerned about Nubia, and a conference was set up between the foster mother and the teacher and the principal. The foster mother comes into the school to discuss the issues. They were concerned that Nubia was falling asleep in class. They were even more concerned that Nubia was really upset because when they told her that they were going to call the foster mother to inform her that she was falling asleep in class, she became hysterical and afraid. The foster mother came to the conference, and according to the principal, she appeared defensive. They told her, the school, that Nubia was afraid, that she didn't want to go home, because she had been, and that she promised that she would not fall asleep again as long as they didn't call the foster mother or send her home. The foster mother, what had occurred was that they did call the foster mother even though Nubia had been afraid, and the foster mother said, when they called her and said, Nubia promises not to fall asleep, the foster mother said she was going home. Nubia was going home at that time. They did not leave her in school. The principal was concerned that Nubia kept falling behind in school. There were a number of school absences, the early pickup on Wednesday, and for example, they would tell the foster parent there's a spelling test, for example, on Friday. Nubia was falling behind in spelling, and for some reason, Nubia would miss Friday school, knowing that there was a test that day. They wanted to get information. That's what the conference was about. We asked the school if they were aware of any medical issues that the children had. The principal said that no, they were not aware. The foster parent was very private and wanted to keep it this way.
Did Nubia have an individual education IEP?
I am not sure if she had an IEP at that time. I know that Victor was in ESC classes and Nubia was in a specific class with more educators or aides with her and a smaller setting, so there is a possibility they may have been an IEP, but I did not review the IEP at the time if it was there. We then asked about testing for Nubia and Victor because they were being retained. We were informed that when children get retained from school, there's a process. There's a letter that goes out first that tells the parents there's a possibility that your child or children may be retained. This letter went home after the Christmas break, approximately February 16th, 07. The letter was signed by the foster parent and sent back by the school March 2nd, 07. There was...
Are the children, both were retained in first grade, right?
Yes.
Are we now a year or so later? What grade are they in now?
Oh, the summer? Okay, they were going to be going to first grade again in the fall. So this happens 07. While the TPR trial's going on, they're being retained. That's when the retention issues. The school was a little concerned that from February 16th, it took till March 2nd to get that letter back, retention. I guess the idea was if your child's being retained, you would kind of, react. A second notice is sent out in April, letting them know that, most likely they're going to be retained. Again, it is signed by the foster mother. The school during this time gets a call that the foster mother was against retaining the children, that she had not received any notice that the children were being retained, and that she didn't want to split the children up. Victor was definitely being retained. Nubia was iffy if she was going to finally be retained. And the school was concerned because they didn't understand why a parent, knowing that the children had such difficulties, would want them to go on to a grade where they couldn't handle. And one of the later concerns that she testifies to is that by second grade, you need to be able to work independently. And Victor and Nubia received so much extra assistance that there was such concern that they wouldn't be able to handle a grade where they're not supposed to receive as much assistance. Nubia was in a setting with 4 adults, only 20 kids. She got a lot of attention. Nubia was not ready to work independently because she got so much help. Victor had D's and F's. The school was not aware of any tutoring because the children were picked up by a park service, after-school program that would pick the children up straight from school and take them to a park for after-school care. There was concern for the early pickup because both had language arts that lasted 2 hours in a day. And again, they were picked up by this bus, and they were picked up around 12:30 or 1 p.m. The release time was 2 p.m. So the foster mother had stated to us that she was only picking them up 10 or 15 minutes early. The school was saying that no, it was 12:30 or 1 o'clock. It was a lot longer than 10 minutes. But the principal did not bring with her the sign-out logs of when the children were released with specific time. She was concerned that Nubia was not kept clean. They did not wear uniforms with emblems. They wore the school colors, but they were not in proper uniform. She told the foster parent that there were vouchers available if you couldn't afford to have the proper school uniform. She was concerned about the applesauce in the hair because it was still there the morning after the incident with the applesauce. She said Nubia was saving food in her book bag. And the principal, when she testified, this was shocking to me. That it wasn't that Nubia was just taking food and stuffing it in her book bag. She was actually, for instance, if she had breakfast at school and she had toast, she would wrap it in a paper towel and then tape it to carefully save her food. And how they realized that she was hoarding the food was one day Nubia was picked up unexpectedly and she lost it. She just became hysterical that the foster mother was picking her up early without her knowing. And she was scared that the foster mother would find the food, so she stuffed it in her desk, and the teacher discovered the food. So what it was that Nubia was hoarding the food. She was carefully putting the food away, and when she found out that I guess the food was going to go home, she made sure it stayed in the school so no one would see it. The principal continued to say that something did not seem right. She said that she couldn't tell if it was the placement or not, but that there was something that just was not right. She had gotten a call from Royal Palm Elementary's principal to give her a quote-unquote heads up that something was going on with these children.
Royal Palm is where the kids wear the uniform?
Yes.
In kindergarten?
Yes, and you will hear testimony from their kindergarten teacher as well at this evidentiary hearing. They had only been at Royal Palm for 3 months. They had been withdrawn in May. Yes. May 06. No, yeah, because then they start Blue Lakes in fall of 07. Yes. Okay. Principal was concerned because they were really strongly thinking about the retention, and the foster parent was totally against the retention. Let me see. Mother had given. Okay. They were concerned about the absences. The school was also concerned because they had not seen anyone from the agency/department or the guardian coming to the school. But they did state that once they had spoken to me in March of 07, that the guardian did start going to the school at that time. And the school, the principal had called me because she wanted to know if somebody could help. DCF, the guardian ad litem. She had received a letter because I asked her why did she call the guardian program, and why did she, how did she get the information to call? And she said that the foster mother had given her a letter that the children had to testify and were going to be missing school, and there was a phone number. And when she called whatever that number was, the principal didn't know. They referred her to the guardian ad litem program. In turn, she calls me. And that's how I get the phone call from the principal. She said that the principal felt that after that conference with the foster mother, she felt that the foster mother was avoiding her, that the foster mother would go into Nubia's classroom, would deal with the teacher directly, but the principal didn't have any other interaction with her. When asked why she didn't continue to pursue the foster mom, she says that as a principal, the teachers come to her when there's an issue, then she does the conference, but she leaves it to the teacher to deal with the parents on a day-to-day basis. Let's see. We asked her if a teacher had come to her prior to the previous principal. This principal had started at Blue Lakes Elementary in October, November of 2007. So for August, September, the first few months of the school year, she had not been at the school. We were concerned if the prior person in her position had received any information from the teacher. She said that she was not aware of that. Let's see. She said that the foster parent had said that she was constantly asking for help, but she said that that was not correct because they were both being retained, and one of the things that the foster mom had requested was specific teachers for the kids, and the school had abided by that for the next year since they were being retained, because the children did in the end get retained to the first grade regardless of what the foster parents had stated, but that the foster mom had requested specific teachers. That was just some testimony that came in. I don't have any details as to that. Let's see. They were picked up 14 to 17 times early on Wednesdays.
Wednesday's early release day.
Yes. Between 12:30 and 1 o'clock. Releases at 2 o'clock. The teacher was concerned that she didn't see follow-up with Nubia. For example, as I stated already, she knew that there was a test, the spelling words, and then Nubia would miss for test. She didn't see the follow-up with the foster parents. They would do all this work in school, and then they didn't see the results or any type of engagement school-wise.
Can I cut to one chase?
I'm sorry?
Can I cut to one chase?
Yes. Sure.
First, how long was she how long did she testify?
An hour.
And
About.
would she be cross-examined in any way?
She was. She was in a certain way because there was this... there was no reason to believe by any of the reports that we had received all this time that these foster parents were doing anything wrong. So there was a concern that this was the guardian against them. So there was some questions towards the school, such as, well, why didn't you do more? As a school, why didn't you test?
Who are these questions coming from?
The department.
The department. You listen to this, and you would say these are signals of the highest order. How seriously did folks take what the principal was saying? Here's a principal of the school who you say earlier, boy, this is unusual for somebody to call. She testifies with lots of specificity. I realize all of this is easier in retrospect, but it just seems stunningly tragic to me. Makes you cry. Truly makes you cry.
It sure does.
And yet it seems so obvious listening to the principal's testimony that you would say, my gosh, there is something really wrong here. So what did happen?
But we had those experts. We had those psychologists telling us that it was detrimentally harmful to take these children. They would never attach with any adult in their life again.
These are the experts who didn't talk to the school.
Right, but I mean...
I can't imagine a more neutral witness myself than a school principal.
Right, and that's why we put it on.
Have more credibility than a school
Right.
principal. I can't think of
Well,
it.
let's go on with the hearing second.
Okay.
Because everybody's point here is that this is pretty compelling stuff. And you have these experts that are saying something otherwise, but the experts' facts are not current. Now does the judge finish the scenario with the witnesses? Who are
Okay.
the other witnesses that testify?
Okay. Right before I get to that other teacher, it's one more teacher and that's it, and then the foster parents. I just want to say that the judge,
The experts testify.
not at this point. Just so you know that the judge herself questioned the principal because she wanted to know if the school knew of any of Nubia's medical conditions, and the principal said no, and that the school was never aware that if you don't share the special needs of a child, they can't help, and that parents and the school should work together.
That's why I asked about the IEP. Because if you have an
Right.
IEP, you have to have these sessions with the parent
Right.
and the school, and these issues
Right.
are flushed out.
That's the end of the testimony for the principal, Ms. Morera. The next person who testified is Alma Bartley. She is the kindergarten teacher from Royal Palm Elementary. She taught kindergarten while they were there from approximately November 2006 to February, March 2007, when Nubia and Victor were withdrawn from Royal Palm Elementary.
Withdrawn in May of 2006.
They didn't finish the year before. Yes. She was Nubia's teacher. Now, Victor, go ahead.
I just want to get these dates right. I think she taught him from November 05.
05. You're right, to February. Sorry about that. February, March 06. She was Nubia's teacher. Victor was with another teacher. She said that Nubia was very nervous. She needed a lot of reassurance. She was tiny and thin, and that she helped her quite a bit. She did not know of any of Nubia's medical conditions. She at one point did see a scar on her head, and she questioned the child about the scar, but the child didn't know how she had gotten it. She said that after 25 years of being a teacher, experience was her greatest teacher. She said that I asked her for an example, and I really want to give you the detail of this example because it's very telling. She said that Nubia had wet her pants. She said that was typical for a kindergartner, no big deal. She didn't have the extra change of clothes for Nubia, so she told Nubia she was going to call the foster mother. Nubia went hysterical. She asked her to not call the foster mother. The teacher went on to testify that kindergartners usually want mommy to come. When they hear that mommy's coming, They know that mommy's going to make everything better or okay. She continued to try to calm Nubia down, and when she asked Nubia why, she said, Mama is going to hit me with a chancleta, that is a flip-flop for the Cuban population, on the bottom of my feet.
That should be a sample, wouldn't it?
It's more like a flip-flop.
I think it's
A chancleta? Right, like a flip-flop. Yeah, it's a flip-flop. They got great aim. Yeah. Nubia had also had gone into the bathroom immediately and was crying hysterically, and the teacher was trying to reach her, and they were having this interaction in the bathroom.
If you hit somebody on the bottom of their feet with something like that, in my understanding, that's a particularly tortuous thing to do. It's not the same as whacking somebody on the butt, right?
That's what I have learned in my work here in the last couple years. I'll be completely honest with you. I did not know that at this point, but I've had enough cases now that I am fully aware that that is, from what the experts tell me, a sign of torture. No bruises are left. Right. When I heard this last night, it was extremely overwhelming. Can I have one moment?
Sure. Please do.
Why don't we take 3 minutes to get some water? Is that all right?
Please. Sorry, guys. I just needed a moment.
Air conditioning units, when you get in, it has this rattling cage above it. Are you saying it's a double tree?
I know everybody.
It's funny, man. You get these epic devices where you I don't know what he's doing where
Oh, thank you. It's a realizer. No, it's okay. No, I don't think either. Just, no, you get into it and you don't. Yes, I realized I didn't. Yeah, and I didn't want to say anything specific. I just thank you for it. To remind me. I appreciate it.
I kind of advise guys before I'm active and be careful.
Well, Dr. Levin, that's his thing. I'm just right. I was just saying that. He's going to do all to the yeah, good. Okay. Thank you. Right. Yeah, that all came out in the hearing, I know. Because the teacher testified it to
We still can.
You don't need it anymore?
No, I copied it on.
Thank you.
Is it?
For what you were saying.
Okay, that makes me feel good. I listened to it last night and I try not to summarize it.
No, it was thinking, oh my God, this is just what I told my people when I listened to it, I said, it'll bring tears to your eyes. It is so good.
I had a moment. I know. Well, that's our human side, right? Gotta be human with this. Thank you. I know. It's just this. there's moments that if I think about it too much, you try not to. Oh, thank you.
Right.
I try not to think about it.
Javi with his little sanitizer.
You know what? Mine's in the car because in court, I don't know about you. When I get to that building, I have to like shower afterwards, right?
You're doing very well. It's
Okay.
very easy to understand for the journalists and for everyone here. You're explaining it well,
Good.
and you're present with the panel, which is good. If they ask you something, you're doing great.
I'm being honest.
Yeah.
You know, and I know, there are shortcomings, but it's a difficult case. This is not so black and white.
But I like how you said, and it was very true. In different moments, you said, well, in hindsight now, of course,
At that time.
and
At the time.
then, and that's. And when that comes up, you can just say that because it's true.
No, it is.
And this is a whole thing. It's for learning. We're
No,
gonna
it
bring
is.
out
Unfortunately,
unfortunately,
we have a tragedy, but it's funny because at the beginning, I don't know if it was yesterday, he said, you really want to be part of this case? I said, that's the only way I'm going to be able to even have Nubia have some justice. You know, because, she can't die in vain.
right.
She can't.
Just to let you guys know, I was watching again on the news. They're again at the house. They've been there. They took the bathtub.
is out.
They took the bathtub.
Midnight last time they were taking her out.
Yeah.
Someone was there live when it happened.
They're
I wasn't
always...
sleeping.
Trouble, the 7 is around the clock. They're calling me every 5 minutes. Is he still out of the hospital? Oye, you will not find out. You'll find Osama bin Laden before you find
But they already moved him. I wasn't sure if they had or
No
not.
sé.
No sé.
No sé,
Gotcha.
ni quiero saber.
That's right. Gotcha.
Pero you're doing well. Your hair looks good.
Okay.
Yeah, I know, because nobody remembers what you said. This is like your mom will see you, your neighbors will see you. Nobody will say, like, you give great testimony. The people that know you, they'll say, ay, Lucina es de lo más linda. O my mother el otro día, estabas un poco cansada. I'm like, Mom.
Yeah, and the Ezra's like, we didn't bring him for makeup. I'm like, that's okay.
No, you did. That's okay. But, like, I totally understand. Like, Sunday, a friend of mine called me, like, you're working, and then the weekend hits.
You've been very helpful.
Thank you.
Sunday, my friend called me. They got back from their honeymoon, and they said, how's work? And I just, I cried all Sunday. Then I got up and I went out.
I've had my moments where I'm doing, a brain moments where I'm driving and I'm like,
I think I'm going to call EAP because I'm telling everybody to call EAP. Call EAP if you have a priest, a rabbi, whoever.
well, and that's what I've been doing. I've been talking to a priest and a nun. It's so funny because because it's like it's the only way, and you got to talk to people where it's confidential, and you can't. I don't want to take a risk. And my friends are great; they're all calling. Everybody's traumatized, but it's like, I can't. And like, no, we understand. We want to make sure you're okay.
But if you're getting that type of,
Is it over here?
Scott and I got a meeting Friday. He wants to come up and shadow.
Yes, it did. Actually, it's been great. Here, right? Much better. All right.
I don't know. I wanted to go down and shoot Monroe County, the 10 o'clock meeting there. I think later, yeah, Glenn's down there. I just manage all that.
Ladies and gentlemen, let's return.
We put almost 99%.
Christy, this has been truly special, and thanks for bearing with us and going slowly with us, and why don't you proceed?
Okay.
So far, 2 witnesses have testified.
Correct.
This is Ada Herrera,
Right.
the principal over at Boone,
Right.
and also the teacher,
Miss Bartley.
Alma Bartley, the principal in Westmont.
Correct. And her testimony is almost done, and then we're going to proceed to the foster parents' testimonies, which is also brief. Ms. Bartley testified that she did speak with the foster parent a couple of times, but the main concern of the foster parent with Nubia was that she liked to hug people. She would, in a mall, just go run up to a stranger and hug them. And there was concern with that because of the sexual abuse allegations that had come in, and her testimony as to what had occurred with her biological father, that this was behavior that obviously unsafe because you don't want children just going up to strangers, but also there was a concern because of the potential of her sexualization.
Was there any testimony about any acting out by Nubia?
No.
Any sexual actualization?
Not during this hearing. Not during this hearing. The information that we had as to her acting out was from the foster mother as to what she had observed.
Is the only testimony of that nature?
Yes.
By the foster mother? No one else testified?
Right. And that was before. That was way before.
So she complained that a 5 to 6-year-old child would go up to people in the mall sometimes and hug them.
Right.
Sign of tremendous bad conduct.
No boundaries. No self-boundaries, one. No boundaries with others. And just the concern that you go up and you hug someone. When you hug someone, you tend to get close to them. Mm-hmm. The concern that, she was doing that with strangers. That was the foster mother's concern. She said the teacher went on to say that the foster mother had no concerns as to the grades. Although the parents have to sign report cards, she had not seen significant improvement in the children, that there were concerns over the grades. The foster parent was asked if she ever called the foster parents specifically with concerns, said no. These must have been conversations that occurred when you pick up a child or drop them off in the morning. She was asked if she suspected neglect. The department was the one that asked her these questions. She said that she was concerned. And she actually, it was kind of interesting because Miss Bartley said that what she did was that she went to another foster parent that she knew in the school that had a child in the school and was asking if there were, if you received financial assistance when you foster children. Because she wanted to understand, because she just wanted to know if maybe the Barajonas just maybe had some, financial issues that were the reasons why there were these concerns. She just said that that was something that just came to her that she wondered about.
You mean financial motivations?
Well, if maybe they didn't get assistance, that maybe some of the concerns was that they didn't have the money maybe to help them with tutoring, or she was trying to figure out what exactly foster parents received as part of fostering children. That was the end of the testimony for Ms. Bartley. The foster parents then got on the witness stand, and the judge asked them why Nubia was going to school unkept. And the foster mother said she is not unkept, that an investigator from DCF had gone out to the home, that they had looked at the home and had looked at all the uniforms and shoes of the children. There was concern from the school that the sneakers were really worn out of the children, like very neglected type thing, and that the investigator had checked even the soles of the shoes, and the shoes still had the rubber markings. They weren't totally worn out. And she testified that the investigator that went out specifically asked her if she had enemies at the school.
Slow down. Say this again.
Okay. Okay. The investigator, the protective investigator with the department, goes out to the home when the abuse reports are called in as to the children not having the proper uniforms, looking unkept and unclean.
This is in response to the hotline call.
Correct.
So this is the mother saying what the investigator did.
Correct. The investigator went through all the uniforms, the shoes in the home, and said everything was fine. The investigator also asked the mother, do you have any enemies at the school? Like, why is this being called in? Everything looks like, status quo, kosher in the home type thing. The foster mother said that they do not go to school dirty. There was testimony that, if you see the children in the morning, they're fine. If you see them in the afternoon, of course they're going to be dirty. Children eat and play at school and get dirty. That each one has a toothbrush and their own cologne. That the father, Jorge Barahona, handles the boys. She handles the girls. And she herself puts the cologne on Nubia every single morning. We asked why there's no tutoring for the children. And she stated that they do get tutoring, but it's in their after-school program at the park.
Was she asked about the incident involving hoarding food, the applesauce in the hair overnight?
She said that those were...
The story about the flip-flop...
No. All of that, none of that has occurred. The applesauce did not happen. The child's diet needs to be regulated due to her medical conditions. She said that the reason she pulled the children out of Royal Palm was not because there had been concerns, because no one ever told her about these concerns, was because she had another child at Blue Lakes Elementary, and it was easier for her than to be... going around town to 3 different schools. A daycare for the baby in the home, Royal Palm for Nubia and Victor, and Blue Lakes for the other child. She was asked about the absences. She says that she did not pick up the children at noon, that she got them at 1:50, and that she's asked for the records from the school, but they say that they don't have them. And again, the principal did not bring the logs with her.
I'm sorry, Chrissy. She said that she took the children out of Royal Palm to put them in the other school. Did that happen in February of 06? She took the kids out of Royal Palm in February of 06. Did she then put them into the other school?
That I do not know. I know that they started in the fall of 06. I don't know if they were there for that last month. They had to have completed kindergarten to go on to first grade, so I'm not sure if that occurred at Blue Lakes Elementary or how that worked. I don't have the details for that, and we didn't ask. She had told the principal, Nubia had 20 absences aside from the 14 early releases because of court and doctor appointments. She told the principal that Nubia was on medication, and that when the medications are elevated, that she gets hungrier and the body odor that the teachers were concerned about was, not due to neglect, a private matter.
Do we know anything about the credibility of that? Was there any testimony about the credibility of that, her medical needs,
No.
vis-a-vis hunger?
No, only the letter that you already asked me about from 2007 from Dr. Sanchez.
Does he address that? I haven't seen that letter.
That there is a possibility that she's hungry and that she could overeat and that there could be body odor, adult body odor. But that's all that I know as to what was in the, whatever was written in the letter. That the children do have a therapist that goes to the school to see them and tutoring after school. That the children, then the judge questioned us if the children had had a psychoeducational assessment. And we stated that we didn't know if one had already been completed. The judge said they needed one. The principal was called back in to ask how long it would take to get one done. We were informed that psychoeducationals are a last resort. They're not, I don't want to say last resort, it's the last part of the process. There's a process that the schools go through before a psychoeducational assessment is to be conducted. There's other ways to mitigate and try to help the children out. So the judge actually ordered one in August to be done as to the children. The judge informed the aunt and uncle that, she knows that they're an alternative, but that she was very concerned because it was very disturbing to know that Nubia is petrified of the foster mother. The foster mother responded, they are happy at home. Wish you could see them at home. I myself stated to the court that I had met the foster parents during preparation for the TPR trial, that when we received the call, I was shocked because I never imagined that these foster parents could be mistreating these children, because I saw their interactions with my own eyes. We did feel that we had to investigate the allegations by the school, but our intent was to help them. Our intent was to make things easier for the Barahonas to foster all these children and adopt them.
This is your testimony?
That's what I informed the court about.
And you're saying it looked to you as though everybody was happy and hunky-dory?
That was, no. What I informed the court that this was that we were all shocked over this happening, that we had no idea. Everything seemed to be okay, and what we want to do is solve the problems by putting services in the home. That we, again, removing the children from the home would be traumatic and detrimental to them, and we would like to get them reevaluated if possible.
Is the world works, you think back about what you say and what you think. What do you think now?
If I could go back?
Yes, ma'am.
First of all, the evidentiary hearing wouldn't have lasted 2 hours. It would have lasted days.
And what else? And believe me, I know this is in retrospect, so
I know.
we're trying to learn something.
Absolutely.
So the next time that there should be an evidentiary hearing of days, it
Absolutely.
ought to go on days.
Absolutely.
Tell us what we all
Absolutely. And I apologize for the emotions, but they're they're children. I would have gotten all their teachers into court. I would have had Dr. Di Tommaso and Dr. Archer come and testify again. I would have had found a way to possibly speak to these children, somebody that they could, maybe their therapist, hearing that they had a therapist. She wasn't even included. Did they even have the right therapist for the trauma that they had endured from their own biological parents? Would have gotten the doctors involved? Would have actually had the doctors speak to the teachers? Had the teachers speak to Dr. DiTomaso and Dr. Archer? And would have just had much more communication between everybody involved.
Let me ask you a question. The players in the courtroom are, you have the judge. So I just want to make sure everybody understands this. You have the judge, you have yourself there, you have the guardian ad litem there, Mr. Newman, and then you have the attorney for the guardian ad litem, it's you.
That was me.
Okay, and the guardian ad litem is essentially the court-appointed guardian, speaks for the child. Okay.
For the best interest of the child.
Solely.
Solely.
Okay, and then you have the foster parents. Do they have attorneys?
No, they never got attorneys.
Right. And then you have the Texas couple?
Yes, with their attorney.
With their attorney. Okay. And then you have DCF there.
Yes,
And do they have an attorney present?
the DCF attorney. Sorry, the agency's present, CFC was present, and then the department was present with the CLS attorney.
So, the department speaking on behalf of the family, I guess. So you're there for the child. The guardian.
Right. Correct. But the department was very clear during the hearing that they were also there for the best interest of the children. It's just that the best interest of these children was not to move them. That was the best interest.
Or so thought it.
At the time, that's what we were told. And, you know,
It seems like you're.
but here's the thing. We're not experts. I'm an attorney. I'm a parent, and I know certain things, and a school calls me, boom, red flag. I have a lay guardian, excellent person, who also is, wait a minute, something's going on. We all knew something was going on. We just couldn't figure out what that something was. Because the experts, the people we rely on to do our job every day, was telling us, you're going to hurt these children more if you pull them out of the house. That's what I had. Now, in hindsight, experts maybe need more information.
I don't mean to interrupt you.
Right.
It sounds pretty clear here to me that you have experts, you have two doctors, and you have a pediatrician. And from what you told us, they had not spoken to the school.
Right.
So, and the school's information is very material to the well-being of these children.
Right.
So they're doing their examination with incomplete information.
Absolutely.
No, you knew that. And I'm not faulting you. You're
No, I'm not.
You knew that. Right? Was that made clear
No.
to the judge?
No. You know what? I have to disagree with you. I have to disagree with you that we really knew that. There's an assumption that might not be the correct assumption, okay? Not justifying the assumption. But there's an assumption that these experts, they know. They know without all the information even. They don't need all the information because these children were so traumatized that no other information would change the idea that their bonding is inhibited for the rest of their life.
You're saying to some extent.
Look, let me finish. And I'm not faulting you. Okay?
I'm not taking it that way.
But somebody's there needs to ask, and it's pretty much a basic question. You ask the expert, what have you looked at? Tell us, what have you relied upon in order to come to your conclusion? And we know from this hearing that the principal part of your presentation will cause you to file the motion is the information you've gotten from the school. So I think it would be behoove, if nobody else, the judge, somebody to ask when the experts made their recommendation, tell us all the information they had. That's what you, when you put it on an expert in court, you say, tell us what you looked at in order to come to your conclusion. And then somebody would have asked, did you receive information from the school? Now, since they were not...
They weren't involved. They weren't involved. It wasn't even considered. The experts weren't considered to be part of this.
The experts' reports were considered.
Oh, right, but not to update them as to what had occurred.
The experts' report were considered. So
Right.
at a minimum, the judge had before her the reports of the experts, the written reports.
Yes.
And if it's a written report, I would assume the report would set forth what it was that those experts looked at. And if that written report excludes the information from the school, and yet the information from the school is what drives your concern and your motion,
Right.
then the expert's opinion is missing a very critical piece of information. So the expert's report really carry questionable weight
Correct.
because it might be outdated.
Absolutely. And we did, and that was one of the things towards the end, that there was an idea of reevaluating the children. The guardian testified that he didn't think the children were unkept. He compared them to other children he saw, and if you saw them alone, they were a little unkept, but with the rest of the kids, they kind of fell into, quote unquote, this is Mr. Newman. He said that at home, they looked a little messy, but, 5-year-olds, some of them do. He also testified that the behavior with him was totally different at school than at home. At home, he would see them only with the foster father. 90% of the time he went to the home, the children were only present with the foster father. The foster mother was not present. And when he would get to the home, they would be sitting around the TV, watching TV, and that was it, but that he had only seen the foster mother a couple of times. He says that at school, they weren't as giggly or smiley as they were at home. And that when they talked about the foster parents, the demeanor kind of changed. Let's see. We then went on to just kind of summarize the hearing. It became more of an interchange with the judge and the parties. Again, the evaluations being emphatic of the detriment of removal. It doesn't make sense to be afraid and attached, and then there was some discussion about, well, there are people who are attached and still afraid, and there was just that general commentary.
The guardian saying to the court they ought to be out of there?
No.
What's he saying?
There's something going on, and we need to figure out what's going on, but let's not move these children now because it can hurt them.
All right, so does the judge, you said the judge orders a further...
The judge orders, the judge ends up ordering a psychoeducational and a psychological. The judge says that Victor and Nubia have been through a lot. They need to be tested. They need to be in individual therapy and family therapy, a psychoeducational and a psychological.
Those take place?
The psychoeducational, I never saw it. It was after my time at the Guardian program. I believe that it was ordered. I do not know if it was actually done.
What is psychological?
I want to say that was when we got the response. There was the one that was done before was too recent. There's not a need for another psychological, but I cannot verify if one was eventually done.
All right, so if we wanted to know whether there was a follow-up on that...
Can be found out.
Now, did the court actually order it?
Yes.
Okay.
Yes.
Did the court make her ruling at that hearing pending receiving the report?
No. What the court did was there was the ruling at the court was, let's get these things done. Guardian, you need to go to the home. You need to be able to go in the home. She had made a ruling back in the June 29th hearing at the permanency that the children were appropriately placed for now, based, because the evidentiary hearing hadn't occurred, but she did not find them inappropriately placed after the evidentiary hearing.
But here's what I don't understand. You have all this testimony. Okay, and again, you have these experts' reports that are based on incomplete information. She orders another psychological report. Does she do that after she denies your motion?
She didn't. officially deny the motion.
Did you say, let me take it under advisement pending the receipt of a further report?
No, it was kind of like, we're going to address this as we get the information. Kind of like the evidentiary hearing would continue on. There was no finality to it.
Who do we talk to find out what happens next in court with this psychological report? Is that you?
No, because I left the Guardian program at the end of September.
All right, so how do we, what was in place to make sure that this report was obtained?
I don't know.
Was there any deadline for the report?
No.
And was the presumption that the doctors previous would do this again? Was that part of it? Dr. Archer and the other?
Oh, I'm sorry. We're going to find out about it. I remember that the principal came back in and we asked how long it would take to conduct a psychoeducational. She said that she had the power as a principal of a school to bump the kids up the waiting list. The judge asked her to do so for Victor and Nubia to get it done. She said it would take approximately 60 days. But that they could be done. Our concern was, well, school isn't starting until end of August, early September. Do we have to wait till school starts? She said, no, psychoeducationals are done over the summer. There were hearings in, I believe, October and November, and I have seen some notes that say, still pending psychoeducational. So I'm not sure when the psychoeducational was completed. But the one thing I don't want to forget to say this, is that the foster parent was asked about Nubia being afraid of her, and her testimony was that the children were not afraid, that she wished we could all hear Nubia telling her that she was going to be her mommy forever, and that yes, they do tell her that she has to behave in school and respect the teachers. So she would get the reason she seemed to be petrified was because they were so strong about telling Nubia and Victor, we don't want to hear you're getting in trouble in school. You have to respect your teachers. And the judge's response was, that's what all parents do.
And your hindsight was easier?
Yeah. I think it was an easy excuse because I think as parents, I think none of us want to get the call from the school that our child is misbehaving. Learn to respect your teacher. I think that's something all parents do, or at least, the largest percentage. But now, listening to her answers just in general, every answer was covering up something that was going on.
In hindsight, the picture I'm hearing you say is we have experts who automatically get some extra poopy dust, right? They're experts.
Right.
And in fact, you had extraordinary testimony from a kindergarten teacher and a principal saying, boy, there is something going on wrong here. And in hindsight, boy, I wish everyone had listened more to the principal and the teacher. Am I hearing you?
It wasn't even just listening to them more. I don't think how much clearer can they say it. Trusting their experience and knowledge as educators of what they see every day, seeing children day in, day out, knowing the signs that they know. But again, I think communication and something that I've learned here at the department to do is when we do evaluations in general, a lot of them are based on self-reporting of the person who's being evaluated. For example, and I don't want to take up a lot of time on this, but for example, we send a parent to a mental health assessment. Well, if the only information the mental health assessor is getting is from the parent, they're basing their decision on that self-reporting. So,
when you're trying, as we all are, to learn something from
correct. What we do,
what you're learning, at least in part, I wish for every such child that we had a better avenue to hear from everyone, and that absolutely ought to include the school system.
Without a doubt. Without a doubt that the school has to be involved, but not rely so much on self-reporting of those that are where the information is coming from, is more conversation with the experts beforehand and giving them the information, which is something I try to do in my practice every day. Is if they're going to be seeing someone, there's history that I know, that I've gotten information that they need to know.
But you're also saying that experts who may have doctorates of one sort or another are not inviolate from human failure, and that when we think of experts, we ought to be thinking of some other people, including people with common sense, including people with teachers with experience, including principals, etc., right?
Because that's all of us. We're all...
Let's deal with the specifics here. I mean, this is what you testified to this very clearly. You have these experts giving reports, and it's apparent to everybody that they haven't been put together with the school system, so they're missing facts. So what I'd like to, so now you know that, you know about the facts, the judge knows about the facts. The experts' reports are in place, there's no mention about them talking to the teachers or getting any information from the schools. The judge orders a psychological evaluation. So what I'd like to know from somebody is, what happens next? Is that done? And what I have from my, I don't have an answer, but what I have from my outline is that Dr. Archer completes an evaluation in February 12th. So what I would like to know...
Of which year? I'm sorry.
February 12th of 08, Dr. Archer completes an evaluation on Victor and Nubia and recommends adoption by the Badajonas. Now, that's the next, in my outline that's been provided to me by the department, that's the next event dealing with a report from a medical person. And what I would like to know is, does he have the information from the school?
Right. And I cannot testify to that. I left the Guardian program in September. When I came to the department April of 08, I was not placed in Division 9 where these children were. I went to a different division. So I was not aware of Nubia and Victor's case. The only thing I can tell you is that my first week here, when I went to visit at the Guardian program to let them know I was now a DCF attorney, and I have very high regards for the Guardian ad litem program. One of my first questions, I remember certain cases, were how are Victor and Nubia? And I was told they're still in the adoption process with the Barajonas, and the appeal had been denied, which I was happy about because the trial for the father, had worked, for a lack of a better word, and that's the last I hear about anything having to do with Victor Nubia.
Okay, so, all right, and I appreciate that. What I would like to know is, because I would testify very clearly about the information from the school. I understand that the school system may have a well-founded concern about having those educators appear. But you've communicated what they would say and testify. Does that information get into the hands of a doctor?
I don't know.
Okay.
I really don't know.
I'd like to know.
Okay.
Pete, you're hearing this clearly, I suspect. What we see here is that the same doctor who performed the earlier evaluation confirms his previous judgment, right, Pete?
Yes.
So, and then Bob asked, rightly so, in confirming that previous judgment, what else does he take into account, including what we hear from a principal and a kindergarten teacher?
Because I would imagine that a judge would be entitled, and you people at DCF as well, to the recommendation of an expert in their field. So I would like to know whether that expert in that particular field reviewed the information, the alarming information from the school. I think that would be very pertinent to our inquiry.
Okay.
And the same thing
Okay.
with the pediatrician. It may be that he made his recommendation without that important data.
Pete, is somebody like Dr. Archer, does this person do case after case after case for the Department of Children and Families?
I believe so.
Actually,
I can talk about how exactly she's appointed.
Okay. Normally what occurs is when we need an evaluation or an expert for whatever purpose it may be during a case, we require a court order. We go to court. We ask for a court order, whether it's a child or a parent or a foster parent. The agency then refers to one of our psychologists, for lack of a better word, experts that we use. Dr. Archer and Dr. DiTomaso happen to be two experts that are used very widely. It's common for them to do evaluations.
They might do how many a year?
Well, when I've had them testify in cases, and you ask them when you're qualifying them as an expert how many evaluations they've done, it's in the thousands, because they don't only do evaluations for the dependency court system, but they also do evaluations for the criminal court system. So they are constantly doing evaluations for us. They do different types of evaluations. It could be mental health assessments, psychologicals, ability to testify. It depends. Like I said, we try to speak with them to let them know, that they're evaluating the child and any information that they may need, history that they need to gather. I don't know the exact number of people, but I know the handful of experts that I use, and at least in my cases, in my caseload, and in my division, we tend to use certain people over and over that are very familiar with the dependency court system, and there are experts.
One side of that would be, but here's a person with an enormous amount of education and experience and sees a lot of things, etc. There's potentially another side to this, which is,
sure,
or are we moving these through and even jamming these through? Because we've got such a caseload of folks that we've got to get the thing moving. And then the other question, of course, is how do you interface with, how do you connect with the other information? So what you want is the other, quote, experts, whether it be the school system or whatever, so you end up with a report going back to the judge or the department.
Right. Sorry, but there's an issue with that. There's an issue with that I have found. And I'm only talking about my experience as a CLS attorney. There's teachers, we can subpoena them to court and all that, but they're great. Their job, what they do is fabulous work, but they don't testify all the time. They're not. I don't want to say comfortable, because there's people that are comfortable as witnesses and some that are not. They're not ones to come all the time. They're busy. They're in school, type thing, and they don't make recommendations. Like, I asked this principal, "Are you recommending these children be removed from the home?" I cannot make that recommendation. I am not. I don't have the expertise to do that. So there are certain people that doesn't mean that the information doesn't need to be given to the expert. But they're not necessarily the quote-unquote expert to tell us if a child needs to be removed or not.
Of course, you have people who are forthcoming.
Sure.
We didn't even ask them. They asked us. They said,
that's right.
We're really worried about this. So this is a big red flag up there. And I'm not sure that a teacher or principal would think himself or herself qualified to answer the question, removed from the home. But they could sure add valuable testimony about what they're witnessing. That seems to be
absolutely.
And they did.
And they did.
Let me ask you, you've been very helpful. I think we've reached Chrissy's exhaustion in terms of first-hand knowledge of the facts. After that hearing, is that pretty much your last contact?
It is. It is.
All right. I want to thank you very much. You've been very helpful in laying it all out.
Yeah. I may have, I'm sorry, I don't remember. There was no other hearing after that August hearing. I did want to listen. I've got to listen to the October hearings that occurred. There was some other hearings. I believe I left the Guardian program at the end of September 07. Sorry, yeah, 07, because that's about the time. So I do not believe I was part of any other hearing. If it was early October, I may have been part of one more, but it doesn't ring a bell at all. So that's the only thing, and I wouldn't have any information.
And the transcript of that hearing is available if you want to.
A transcript of which hearing?
The August 3rd?
I actually have the recording, the audio. I have not requested the actual transcript.
I would like to get I'll tell you what I would think be useful is to get a transcription of how it concludes. In other words, the court's last words, her rulings, what she says should be done next.
Right.
I think that could be informative.
Right. What she said, at least from my notes, that She ordered the psychoeducational. She wanted to know when they would be tested. That's when we found out it could be over the summer. Let's see, Gal on psycho.
I would like to, if it's available, I'm sure it can be transcribed.
Right.
Was there?
I'm sorry. The judge ordered again the guardian to go to the home, and he was never allowed in the home again.
Let me ask a couple of questions. First, the guardian then went to the home?
He tried every month. He's required to go once a month. Yes.
Did he then go to the home subsequently?
Yes, and he would not be allowed in.
But then he is removed.
That I don't know. I don't know that history.
We want to understand what the timetable on his removal is. Does the court actually meet in session again to hear the 2 psychological reports?
I don't know, but I do believe that the court met with the children, Nubia and Victor, because I told the court that one of the things I didn't want to do at this hearing was bring the children for them to have to testify yet again. They had just testified in March of the same year in the TPR. So we always try to avoid the children testifying, especially since they had testified in criminal court. And the judge said, I don't want to hear from them today, but I may need to hear from them in the future. And I believe that there is a time when they go into chambers with the judge, and Mr. Newman was present, and the children said they were happy in the home.
So let us have Pete to follow up on that. Christy, this has been really good, and thank you for all you helping us here.
Christy, that was apparent in November 28th, when Judge Bannisher put the kids in, because the parents complained about that in one of their letters.
Okay.
So,
right, and we were informed. Right, and we were informed that they had written a letter complaining about the guardian. At least by August, there had been a letter written, about the guardian, and that's why there were all these conversations. That it wasn't that we were out to get them; it was just that we needed to know what was going on.
yeah, they wrote letters on June 4th, August 5th, and January. It was received in the governor's office January 16th. So,
Okay. Thank you.
Since we're on this topic, is there somebody here who can give us a follow-up as to the psychological report that was ordered by the court?
I've got it right here.
You do have it?
Yeah.
Okay.
Yeah. And
Is there any reference to the psychologist? This is Dr. Archer?
yes, Dr. Archer's report.
Can you get to the lecture?
Yeah.
I'll say, I'll ask you some questions. You tell me what you can tell us. What I want to know is, Dr. Archer, is it apparent from the report that Dr. Archer spoke to the school people?
No. Just as a quick perusal, it's been a while since I've read it. A quick perusal indicates she did a lot of educational testing, or records a lot of educational testing. I don't see, looking through it quickly, I don't see reference to talking to the school personnel.
All right. And then, how would that have been done? Who would have been responsible to make sure that bit of information, which was the information received from the school folks, was put into the hands of Dr. Archer? Maybe Dr. Archer doesn't know about that. What's the step in place? I'm sure there's a process here.
Yeah. Mary, I'm not quite sure. Do you?
Fran can answer, Esther can answer.
The process by which
the doctor gets the background
In
information
other words,
whenever they look at it.
in other words, here's what I want to know. The information from the school, which is very important, very material, I would like to know who should have communicated that information to Dr. Archer so that Dr. Archer was aware that he should look at it.
Right. On average, when we have these type of, you want in this case specific, it would have, well, normally it's the case manager will give the expert the information.
Case manager here was.
I don't remember his name. Okay. Case manager.
A case manager in this case
Right.
knew that the school had made these reports.
Right.
And the case manager in this case knew that the children were to be evaluated again.
Right.
And the case manager in this case should have made that information available to Dr. Archer.
The case manager would have given Dr. Archer the information. The DCF attorney would have given the case, the Dr. Archer the information, the guardian ad litem attorney. What I'm trying to say is that all the parties can give the information and the history to the expert.
Oh, okay. In this particular case, they were all in a position to make that available.
Correct.
Yeah. Okay.
Correct.
So, and then based upon Pete's review of the report from Dr. Archer, just on the written report, it doesn't look like Dr. Archer had reviewed any of the information that you reported about from the
Can you tell them what's on that?
Yeah, go ahead.
And
What she, on her evaluation filed February 22nd, 08, there is a review of records, and what she writes down that are her review of records, it is previously completed psychological evaluations, previously reviewed documents.
but there's no reference to having spoken to these principals.
You give me 1 second just to make sure. I wasn't here.
Pete, I assume that one thing we can, quote, fix here, unquote, is to make sure in the future that these connections must occur.
Absolutely.
So that's not what we've had heretofore.
Yeah, absolutely.
But we can make that happen.
Yeah, that absolutely should be tracked, and the loop should be closed to make sure it happens. Simple as that.
No, there's her other consultation is with Mrs. Barahona.
Okay. All right, so now when Dr. Archer's report is completed, it's presented to whom?
It gets filed with the court. The date of the evaluation is February 12th, 08. And on February 22nd, it gets filed with the court. Normally how it happens is that there will be a court hearing, and we will submit the psychological or whatever evaluation at that date and provide copies to all the parties.
All right, so all the parties, the case manager, the DCF attorney, the guardian ad litem attorney, all of them, and the judge, had available Dr. Archer's report to read.
Yes.
Okay.
Yes, sir.
All those people could see for themselves that there was no reference in the factual predicate of the report that dealt with the doctor consulting with the principals or getting any evidence from the principals of those two schools.
Correct.
That's a pretty glaring omission.
Pete,
Yes.
I think what we're
We'll see
looking,
what they're...
at least what I'm looking as we go forward, as we ultimately make recommendations before too long, is that you come back with a process that doesn't add to the bureaucracy, but does add to the full humanity. And I assume you think you can do that.
Absolutely.
Okay.
Yeah.
But, sometimes I think I get the sense that there's enough process here. That's not the problem. I get the sense that the problem, apart from the fact that underworked, understaffed, underpaid, I get that. But there's also the issue, these are all intelligent people here, that the critical thinking, you don't put that on a checklist. Critically thinking, sure that when you go down this checklist, you're actually thinking about what you're doing. I wouldn't recommend another process. I think I would just it seems to me that's, I don't think you need a checklist to say, take a look at Dr. Archer's report and see whether Dr. Archer included the facts from the schools.
So just so there's a full discussion, I do think there needs to be a process. I think you need to ensure in every instance that all relevant observations are included. And I would be horrified if we come out of this and that's not included. Because, Christy, based on your testimony, it just didn't come together. And I don't dismiss in the slightest Bob's point about critical thinking and common sense. But I also think we need to insist that this happened in every case. I'm hearing that this isn't the first time this observation's been raised, right, Pete? I'm hearing in the Gabriel Myers case that there were some disconnects there as well, correct?
Yes. One of the most critical things, just as Christy said, is to get all the parties together, to pool all the information, and to make sure that one coherent picture emerges. considering everybody's evidence, everybody's information. And throughout the life of this case, I see several places where that did not occur.
So then, if I can just follow the chronology, Dr. Archer's report gets filed. Then what happens next in the timeline with regards to that report?
I don't know what happened at that hearing when it was filed on the 22nd.
Does anybody know what happens next?
I think we, Sonia's here, right?
Dr. Lambert's got
They want to talk to Dr. Lambert. He's not here, so I don't know if we want to take a break and let them ask.
Can you answer the question, and then Dr. Lambert has to leave. If she could answer the question and then come back. Go ahead.
I'm Sonia Ferrer. I'm the director of the Guardian Ad Litem program. My understanding from my review of the records is that at that hearing,
This is the one February 22nd.
yes, the evaluation that is presented before the court states adamantly that the children should be adopted by this family, that the only... That's correct. That the only reason why the children have been able to overcome all of the trauma that they've had in their lives is based on the safety and love that has been provided by these foster parents. So the judge then states that the children will remain in that home and be adopted by those foster parents.
Do we have a transcript of that hearing?
I haven't seen the transcript. I'm sure there's one.
President of that hearing.
I don't know everyone who was present. I'm assuming all the parties were present.
Who takes over for Chris at that hearing? Who plays the role of the attorney for the Guardian Ad Litem?
The attorney that we had at the time was Saba Tor, took the case afterwards. She's no longer with our program, so I haven't been able to have a conversation with her.
And were you responsible at that point for the Guardian Ad Litem program?
I was not the director at the time, no. But I have reviewed the records, so there may be some things I can answer.
So I see in here in parentheses, Guardian Ad Litem does not want Mr. Newman to testify due to a pending motion. What's that about?
There's currently 2 motions, one in family court and one in dependency, to exclude the Guardian program. And so, there are some things that we feel we're limited in disclosing because the case is still ongoing and because of that pending motion.
Boy, you totally confused me. I have no idea what you're talking about. What are you talking about?
You're asking me why it is that Paul Newman isn't here?
Yeah,
Right.
I'm really more than that. I'm interested. Yes, I'm interested why you cannot testify here, but I'm interested in knowing, understanding why a person who was seen, at least from Christie's testimony, as doing a good job, high credibility, had a real relationship with the children, and now, if I'm understanding what I read correctly, he is now returned as the Guardian Ad Litem for Victor Nubia. What's the deal on his being removed? What was the department's thinking that he needed to be removed from this case?
Well, let me explain to you what my understanding is from my review of the records of what happened. From the time that the Guardian Ad Litem disclosed the concerns that they had that the school was addressing with regards to the children, and as you heard from Christy, it was almost impossible for that guardian to go into the home and visit with the children. And despite the numerous times that when Christy was the...
Tell me why that is. The judge says the Guardian Ad Litem, one of the conditions is the Guardian Ad Litem must have access to the home.
That's correct. And even though the judge does admonish the Barajonas several times, they still continuously do not allow the guardian in the home. And I'll tell you, it was a period of almost 9 months where they would play games, where the guardian would get there, they would allow them to see the children, but in the front lawn, not allow us to go into the home. And when we would say that to the judge, then the Barajonas would say, well, we were already outside. That's why he was visiting the children outside in the home.
Meanwhile, the Barajonas are writing the governor of the state of Florida and saying this guy doesn't care about these children whatsoever. And I'm just wondering, at some point, does the department say, let's cash in, give up on this one, we'll get another person, sorry, Mr. Newman?
Well, first of all, it's not the department's decision to remove a guardian from the case. It would have been the guardian program's decision. The letters to the governor happened in early 07. Well, not early 07, in August and September of 07. And we did not remove Mr. Newman from the case until August of 2008. And I want to say one thing before I clarify why it was that we made the decision to remove Paul Newman from the case at that time. For all of the people that are here in the community, and I know you in particular, Mr. Lawrence, know Joni Goodman, who was the director at that time, and there was no one that was going to tell Joni Goodman that she needed to do the wrong thing for a kid. So the reason why we removed him was because continuously he was unable to see the children in the home. The only way that he was really able to see what was happening with the kids was at the school. There was a point in time, because that was during the summer, that 3 months went by where he was unable to see the children.
So
and
you had clever and manipulative parents with motivations of their own. I do not know this, but the last testimony would indicate that's possible. Ultimately, the parents get their way, and Mr. Newman's not on the case because he cannot be effective.
And it was something that we continued to address with the court, and that the court did admonish, but that was the end of it. The judge would say, you have to allow the access. The access wouldn't happen. And we felt as a program, we had to have someone lay eyes on those children inside that home. So we felt we really had no choice but to reassign the case at that time to a staff member.
And who was that?
Teresa Graf Sosa.
And she did that then from what date to what date?
She worked on that case from September of 2009 until the adoption. I'm sorry, from September of 2008 until May of 2009 when the adoption occurred.
And what was her picture of all of this?
She did not have the same experiences of the resistance to go into the home, and when she visited with the children were doing well.
And Mr. Newman at one point now comes back?
That's correct. Teresa Graf Sosa no longer works for our program. She works for Citrus Health now. And we try as much as possible when cases come back in to place volunteers, especially with everything that happened with this case. We knew he had a relationship with Victor. We thought, based on everything that was happening, that he would be the one continuity on this case.
But if we asked the previous guardian, she would tell us, from my vantage point, things looked like they were going just fine.
Yes, previously, the one after Mr. Newman, you're saying our staff? Yes, she would say that.
But going back to the timeline here. I'm focusing on May 12, 2008. It says here, judicial review, guardian ad litem, and the agency recommend children remain with Barajonas. Now, at that point in time, Mr. Newman was the guardian ad litem.
That's correct.
So, in May of 2008, Mr. Newman, had he been given access to the kids?
In May of 2008, he was visiting the children in school and in the front lawn.
And in the front lawn. And yet, he recommended that they remain with Barajonas?
He never stopped recommending that they remain with the Barajonas. He did, however, continue to voice during that period of time, and I know Christy mentioned it was an endless evidentiary hearing. It was an endless evidentiary hearing that happened. He continued to voice during that time his concerns about accessibility and what had been raised with the schools. But he never said, remove them from that placement.
Can we say endless evidentiary hearing? Christy left off on August 3rd, 2007. She said the judge made some orders and then goes in for the end of her involvement. Can you tell us what happens next in the legal process?
My recollection of reviewing the files was that there was another hearing sometime in November where she asked for the children to be brought into court. She met with them in chambers, and that's when she ordered the evaluation to happen. And then it wasn't until February that they came back with the actual recommendations from that psychological evaluation.
What happened then? Did the court actually make some sort of ruling at that time?
I wouldn't be able to tell you exactly what the rulings were, but from what I reviewed, the judge did state that this was an appropriate placement and this is where the children should be adopted.
At that time?
Yes.
She said that in February?
February of 2008, based on the recommendation that she got from Dr. Archer.
Just from the doctor?
That's correct.
At that point in time, the DCF or the guardian gave a recommendation?
No, there's nothing that in our file that states that we gave any recommendation at that time.
At some point, the children are homeschooled. When's that occur?
That happens once we're off the case. The children were already adopted at that time.
This past summer. So,
So,
2010.
so we're never getting anything future from,
Anyone. Once the children are adopted, no one's involved in the case.
Do you have a transcript of the February 08 hearing?
Yeah, we do. We don't have a transcript, we have an audio.
An audio is it long? I'd like to hear what the judge has to say.
I can step down to my office and listen to it and come back.
That'd be good. I would like that. Whatever, I'd like to know. Yeah, I'd like to know what the judge has to say.
There's just one thing that I want to clarify before you meet with the next person. I've been doing this work for 18 years, and it is not common for a guardian to be denied access to a home. So I know when Christy was up here giving her testimony, she had recently been working for a program, and she said that was something that happened. Sometimes I can tell you that it's something that rarely happens. Few and far between do we have someone denying us access to a home.
18 years, you've seen it how many times?
I could probably say a handful.
It's no more than 5.
Yes. Okay.
Thank you very much.
Okay, thank you.
Dr. Lambert, I think.
Good morning. I need to just make sure that the panel knows that because I work for the Child Protection Team, that the statute with the Child Protection Team specifically prohibits me from discussing any CPT involvement in this case, specifically related to it's Chapter 39-202, subsection 6, unless there's a court order signed by a judge saying that. So I understand my role rather was to help the panel understand a little bit about Nubia's medical condition. I also want to clarify that Dr. Sanchez is not this child's pediatrician. Dr. Sanchez was the pediatric endocrinologist who took care of Nubia from when she was born until June of 2010, in which the family decided to move her care to a different pediatric endocrinologist, that the children would have had a pediatrician who would have an ongoing relationship. However, that Dr. Sanchez did see this child approximately every 4 months from when she was born until June of 2010.
Dr. Lambert, is it correct? Going back to the timeline, on June 6, 07, it says pediatrician submits letter to Children's Legal Services describing mental care of Nubia and endorses mother's care of child. Is that correct?
I don't know who that person is. Dr. Sanchez is not the child's pediatrician. Dr. Sanchez is a pediatric endocrinologist.
So that's just dealing with her endocrinological issues that she had.
That's right. And she I'm sure, had a pediatrician. I know there's...
So maybe, Peter, because we were told before that that pediatrician was Dr. Sanchez, and maybe it wasn't.
I think you assumed it was her pediatrician. What I heard Christy say was that it was a pediatric endocrinologist. This child would have had, or all children should have, ongoing relationships with a general pediatrician who provides their ongoing pediatric care, their immunizations.
They may or may not have, and that's what we're going to find out separately, and you just don't know the answer to whether the child had a pediatrician, right?
Well, I know who her Medicaid said it was. I don't know if that's actually who she saw. And I presume while she was in foster care that the case management agency had her going to whoever was her Medicaid pediatrician or another pediatrician.
I'd just like to know who in the timeline were given June 6, 2007, pediatrician endorses mother's care of child.
Right.
I don't know who that
I would have no idea.
Okay, I thought someone said it was Dr. Sanchez at the Miller School, but maybe it isn't.
But once again, I'm not saying that person did not write a letter. What I'm saying is she's not her pediatrician.
No, I understand.
Right.
I don't have any facts.
Okay.
Any of this.
No, I know.
When you tell me who was that pediatrician, that's all I want.
I have no idea.
You'll get us the answer on that.
Yeah, well, at this stage of the game, do you know the answer to that, Fran? We haven't been able to find it from the record as to exactly who the pediatrician.
It may be helpful for the panel to read Dr. Sanchez's letter.
I think it would be.
Yeah.
There's a copy.
Why don't I talk about congenital adrenal hyperplasia, and then you can understand what it is. I think that I have not seen that letter either. May or may not be in that. Congenital adrenal hyperplasia is a congenital absence of specific enzymes that break down, and there are several different kinds that break that do not allow in the normal process of certain hormones being made, and because that enzyme does not exist in the adrenal gland, the body shunts what is supposed to be going down a specific pathway, and when the hits this enzyme is not there, it can't make the normal enzymes, and it shunts away and specifically makes more of the testosterone male hormones. Okay, and this is in girls. It generally, like in this case, presented is easier to diagnose in near birth, because many times when it's obvious, they have ambiguous genitalia. That is true what occurred here, and she was diagnosed right in the neonatal period. Today, all children who are born in the state of Florida, this is one of the inborn errors of metabolism that we routinely screen for, because in boys it's not as obvious. And in the spectrum of this disease, one of the things that can happen is that you have trouble maintaining the salts in your blood, and obviously, if that happens, they can present in a salt-losing crisis and die, right? And because all of these inborn errors of metabolism have different penetration, some people have it more and some people have it less, right? So she was diagnosed near birth. I happen to know this because over 10 years ago that I was the medical director of the Children's Medical Services comprehensive, let me see if I can remember, Children's Multidisciplinary Assessment Team that looked at children who needed special needs, and Nubia came into care and was in medical foster care. So it just so happens that coincidentally, when Nubia was in medical foster care, that I remember this case very specifically about that. And she essentially, what happens is that these children take medication to replace both cortisol. So anytime a child is stressed, whether it be by illness, whether it be by not eating well, these children will need extra doses, right? And what happens is, because they get more of the testosterone male androids, these children are like as if they would go into puberty early. And if any of you have had children recently or may remember yourself, like many children in early adolescence, eat a lot. So that hunger is normal. That, of course, appropriate medication should help with doing that. And one of the reasons we don't want to control this is these children can grow very quickly if they're not well controlled early on, but then will end up shorter as adults because they went into adolescence early. And if they're not treated, they can go into puberty, in early childhood.
Very rare condition, doctor? Not so rare?
Well, as a pediatrician, I and at an academic center, it's I don't know the number. I would probably one in what somebody could probably do it on their thing. I'm going to bet about somewhere like 1 in 20 to 1 in 30,000 live births. So it's enough that we screen for it. Something that, I know this one better right off the top of my head than if we were talking about, some, very long chain, blah, 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 they didn't have when I was in medical school, right? It's a very standard thing. In Japan, they've been screening for congenital adrenal hyperplasia from the 70s or 80s. We only started screening for it. I don't think there's anybody here from the health department, but I would say in the last 5 to 10 years. But in girls, the diagnosis is relatively early in infancy. And like I say, within this particular case, she was diagnosed in infancy. Okay. Once again, as with children who are going into puberty and in adults, body odor can be part of that. But like in adults, appropriate cleanliness, good hygiene, and the use of deodorants solves the body odor issue. So it's not that they don't have body odor. And so perhaps at 7, 8, or 9, she had body odor related to that, but appropriate hygiene would, it's not like it's you, despite what you do, you have body odor, right?
Children with this condition, can they end up with what I would think of as normalcy at some point?
If they're treated well, absolutely. If they're treated appropriately, absolutely. The goal is to postpone puberty to normal age, right? And to go on. For girls, even if they have external genital abnormalities, their internal organs are completely, these are all secondary characteristics. It's the androgen. So the inside, she could grow up and have children and stuff. Yes. Right. And, I think that's absolutely true. Right. So this is exactly why they require regular checkups with the pediatric endocrinologist about every 4 months. I did speak with Dr. Sanchez, who told me that, remember, she took care of her when she was in medical foster care. She took care of her when she was with her biological family, and she goes ahead and takes care of her when the children are in foster care, and then a little bit post-adoption from the dates that I just heard. She last saw her in June of 2010. And she tells me that that sometimes there were missed appointments, but when the office called, they did come in.
So she was progressing.
Yes.
Rightly and normally.
Yes, within the range of the illness. Yes, and of course this involves blood drawing and making sure that the hormone levels are appropriate.
Doctor, one of the pieces of this case is hoarding food, the food in the desk, etc. Does that's quite consistent with?
Well, I think hoarding food is different than you are hungrier than perhaps normal. And once again, if the child is abnormally hungry, then that means that the hormone replacement, the medication, has to be adjusted. Because what we don't want is you to become a teenager when you're a child. Right? I mean, essentially, that's what they're trying to do, right? They're trying to maintain the levels of the shunt off, right, low, so that the body, and what you do is you essentially give the medication so the system is sort of turned off. So instead of shunting across is there. So that issues related to eating and would be very important to bring to the attention of the pediatric endocrinologist, because that would say something perhaps to the need to adjust the medications.
Do we know anything about whether this was brought to the attention of Dr. Sanchez?
I do not know that. You have the letter there.
Yeah, but the letter, I read the letter already, but the letter...
Perhaps I can look at it and see if I can interpret doctors probably in a different way.
Well, I hear you're saying that if we have this, if we're all listening to one another, that the hoarding of food, we minimally need to look at this as a signal.
Right. I just see this letter as explaining the condition, trying to, in lay terms, explain what I'm trying to explain in lay terms. No, I don't know what else to address.
But what I was trying to get at with my question is, and again, I think this is about linkages and connections, that if we ultimately have our best common sense and wisdom on, the story about hoarding would be known by Dr. Sanchez.
If the caregivers brought it to her attention, right? And it is not my impression from talking to her that that had been brought to her attention, and Nubia grew well at the bottom of the growth charts, but in the normal growth charts, so it wasn't like she was large or obese. She was growing.
And so
right.
The hoarding story to you, using your common sense, might indicate something more than this.
Yes. And the question I would have about that specific letter was who called Dr. Sanchez and asked her to write the letter, and is it they're saying she has body odor, blah, blah, blah. I can't speak to how that letter comes to being and who she addresses it to. And who the letter, I didn't look at the top of the letter, I just read the body of the letter.
The person to whom this letter is written is an attorney for Children's Legal Services, is that right? For DCF? Help me understand this, Miriam.
Yeah, I don't think so, right, Aleda? I think it was addressed to CFCE, whose name is Aleda Jacobo, and Esther's name is Esther Jacobo.
It's not the same person?
No.
And that's why I think we got a little confused, because I think making the timeline, even the folks in Tallahassee, when they saw Jacobo, assumed it was Children's Legal Services, Esther Jacobo.
You don't see a lot of Jacobos around. So who is this person here? Say it again.
Aleda is here in court. Aleda, you want to introduce yourself? I mean, I'm sorry, not court, but feels like court.
My name is Aleda Jacobo. I'm the Chief Operating Officer for the Center for Family and Child Coverage.
In other words, when these issues came up, I'm going to presume that the case manager contacted the endocrinologist, said these issues have come up, and then they wrote a letter to the agency explaining. I'm going to guess, explaining the condition to the agency.
Well, since we have the person here, we don't have to guess, right?
Well, I can presume that if that's how the letter comes.
Your Honor. Mr. Lawrence.
I'd sort of like Your Honor.
I'm the attorney for CFC, outside counsel for CFC, and I'm going to be making a very brief statement in conjunction with Ms. Allegra from our kids, and we'd rather defer commentary until then.
Okay, help me out of my ignorance, because I suspect I know, but I don't know. What is the Center for Child and Family Enrichment?
That is a contract entity with our kids, which is the umbrella community-based care provider in Dayton, Monroe. It's one of several contract providers. Charlie would be another. Children's Home Society would be another. A Family Resource Center.
And you were our kids subcontractor on this particular case?
For two of the children at a particular time.
Which two children at which particular time?
I really need to make a statement.
Okay.
But this may not be the time you want me to do that.
Well, it also could be. Dr. Lambert, anything else we ought to know?
Well, I just to say that this is just my own comment, right? I should say, not everybody there knows me, that I happen to have been a foster parent for DCF. 5 of my 6 children are adopted from DCF. I was a social worker and worked in child welfare prior to working for the Child Protection Team, which I'm now in my 23rd year. I think that I think it is important that you all understand in making recommendations that the abuse hotline has received almost, I think, 59,000 more reports last year than the year before, in a time in which, at least in our district, the Child Protection Team and the Department of Children and Families in our district have a very close relationship, our district being Miami-Dade and Monroe counties, there's been a extremely, as you're not surprising, large turnover. I'm surprised by how many new names I am writing, and we ourselves are up over 10% of cases, yet last year we were cut. Our program that's only about $18 million statewide was cut $800,000 and is scheduled for a $4.1 million cut. So if in any of the recommendations that you're making come more referrals to us, it's very hard to do that.
How many people on your child protection team?
The professional staff, clinical staff. There's myself, another physician, and a nurse practitioner. We are fortunate that we have a full-time psychologist who is our clinical director who works with us, and we have, as case coordinators, social workers. We have 1, 2, 3, 4, 5, 6, 7 people that covers also the keys, 7.5, and an intake coordinator, the person who does intake. And we, of course, are going to do mostly the cases that are more complex or have injuries. So we probably do of those cases, 10%. I'm not even sure what.
You've been the leader of this team for how long?
July 1st of 1989. I started working for the team on July 1st of 1988.
And you've seen a stunning increase in ratios of staff to...
Well, I think over time lots of things happen, right? But I think what is true, at least for the child protection team, I caution the panel. Let me just say this frankly. I'm not the most politically correct person. That we need to be careful that a case of one is not the whole universe. Now, I just want to say, and for instance, starting in the mid-'90s, every morning I would go to DCF when they used to be over at 3300, and I would read reports every morning, and based on sort of my experience of saying to the child protection team, don't complain about them. We only see this tiny amount. You don't know what the universe is. Now, since 1999 or 2000, every morning we read every case that comes into the hotline every day is read by the child protection team, and within specific things that are in the statute, there are certain kinds of cases which are mandated to be referred to us. Okay? Most of the cases we do are not mandatory cases. I think that's an important thing, that the physical punishment cases in general, which are a significant number, some of which are abusive. I'm not minimizing that, but that this is a big...
Dr. Lambert, let me ask you this.
Yes.
I'm not laying it on thick. You have enormous credibility in this community. What would you have us recommend?
Well, let me just say, from many, many years of reading reports to the hotline, and it's something I heard today, clearly the number one group of people who report maltreatment that is true is school personnel. It's the single most important, much more than doctors, and I believe community people do also. I don't want to say that, but school, what I heard you all say, I think the fact that the school personnel have a sense, because they work day to day with families, and that they know it's not, I saw this today. And it doesn't mean that a given person doesn't do things like asking questions. I don't know that this is true, because I think it seems like these people were manipulative people saying that, do you have enemies at school? I mean, I can tell you I have a daughter who has intellectual disabilities, and I have battled with the school, but I would never say that any of those people are my enemies. Okay, there are days I would like to go down there, but I think that and I can tell you for sure at the child protection team, and I believe that true for most child protective investigators, that cases that are called in by the school system carry a significant amount of credibility in terms of children. Children decide who they tell things to. They don't just pick anybody. They pick that person because that person is going to believe me. And I didn't pick that person, not you personally, right? That person for a reason. People tell who they're going to tell, and teachers, and as a general rule, people don't want to report. So when people go that step to report, I think that's something that I have heard, and I heard very clearly here. And it seems to me that in the retrospect, it was very clear that the things. The other thing that I would suggest is that perhaps you review the literature on missed child abuse. And one of the, at least in the medical literature, clearly one of the things that happens is when families are two-parent households that are of the same ethnic group, in particular if they're upper class or upper middle class, that people tend to shunt away from reporting or believing it's true, and because they present well, people accept their explanations where they would not necessarily from poor, less educated people, even though they're saying the exact same thing. And
did you have the sense of school personnel are required by law to report?
Well, in Florida, the law says any resident. And then in Florida, there are certain groups of people who are mandatory reporters, which means they're mandated to say who they are. And that's a very different thing. There are only 5 or 6 states that are like ours that says everybody shall report. It doesn't say talk to the principal. It doesn't say talk to the guidance counselor. It says if you have knowledge or reasonable suspicion, you must report. And then certain groups of people are required to say who they are. In other states, anybody can, and only mandatory reporters shall. In our state, anybody shall. And I think in a recommendation that I would make, just watching TV, if people were concerned, okay, they should have called the hotline. They shouldn't have talked to the school. They should have called the hotline, because clearly when a lot of reports come in from different people, right, that's taken in a different way than a report occasionally from one place.
Right, Doctor, I think there's a danger. I think we all come with prejudices and biases to this panel. And I think it may be a subject for another day to look at the macro picture. Mm-hmm. I read a very informative article in the Herald that we did for the last week about the macro picture. And I happen to sympathize with that. But I don't think really what the mandate from the Secretary to us was to recommend the macro picture. I think what he told us clearly was to look at what happened in this case, what went wrong here. And so far, just dealing with the facts, and it's a professional impairment that I have to deal with the evidence. The evidence that I've heard so far is that the information from the school wasn't picked up by the doctor who made the recommendation, Dr. Archer. And without going into a name, according to Christie, all that information, the report was reviewed by a case manager, a DCF attorney, and a guardian ad litem attorney. They saw the report from Dr. Archer. They saw that report did not contain any references to the school.
Well, or even in a general sense, to that there had been a very specific report information, not who it was, because remember the reporter as a reporter is confidential, but knowing that there was a specific complaint that needed to be addressed. And I think one of the things I would say that I've learned from working with psychologists is that a psychologist needs to be asked a question. What is the question that needs to be answered? And was the question, I don't know what the question was. Just ordering a psychological doesn't mean anything. I can do a psychological and do an IQ test on you, or a whatever MNMPI or whatever it is, and that doesn't address the issue. And was there a specific question to the court that the court put to that psychologist of what to do?
Right. And so I think just dealing with the specifics. Yeah. I would love for some other day to opine about public policy, but just dealing with the specifics here. Is that a case manager, a DCF attorney, a guardian ad litem attorney read the report and saw that the report from Dr. Archer, there was no reference to the school.
Or at least no reference to the new report. Even what I read there was previously reviewed.
Okay, so the question
doesn't sound like there was new information.
So obviously, it's something that was a mistake.
Yes.
Several times.
Yes.
So
apparently.
The question is why? And it may be that the turnover caused that. We can go into that later, but we know for a fact that appears to have been a mistake. Nobody who read this brought to the attention of the judge. The judge also didn't, she read it, she should have picked up on the fact that it wasn't mentioned in here. But it appears to be a pretty glaring red flag that, for whatever reason, a variety of people dropped the ball on. I mean, that's a fact, right?
Yes. I also think just sitting here, hearing here, the fact that people made these absolute statements will be devastating to a child makes no sense, given that we know children go through trauma and survive, and these children, it turns out, are going to be in different placements, and perhaps the trauma. I think people got stuck in a place, and we're not open to other alternatives.
This has been immensely helpful.
All right, thank you.
Pete, we're supposed to finish for the day in about 9 minutes. And I think we have some obligation under the Sunshine Law, since we noticed it for 8 to 11. Is that correct?
Yes. I think you can go over. You can extend it.
Okay. So can we go to 11:30?
I'm sure you can.
Okay. Then let's do it. And what's your sense of the best use of our time right now?
Well, I'm wondering if the guardian ad litem had any additional things they want to say.
I'm sorry, I didn't hear you.
Do you have other things that you wanted to talk about? Any other questions?
No.
I think we'd like to recommend foster parents who knew the Barahonas quite well. Trudy Pekovich.
Yes.
Let's plan on, for sure, closing up at 11:30.
Good morning. My name is Trudy Petkovich, and I'm listed as a foster parent, but that was previously a foster parent for 18 years. I am an adoptive parent. I have worked for DCF through the Riley Wilson hearings. I spoke there. I've also worked for Kids Hope United as the foster parent liaison, and I subcontract with Our Kids doing post-adoption services and co-parenting initiatives. I also am on the board and have been for many years of the State Foster Adopted Parent Association. I think I am here today to give you an overview of what we might consider my professional foster adoptive parent of the Barahonas. I met them originally in 1999 when they were first licensed at their MAP class. The last MAP class, we were asked to bring in other people from the community to speak with the new foster adoptive parents. Okay, that's the training that foster and adoptive parents go through. It's a 30-hour class that I believe was discussed at your first day of hearings, and that leads to licensing of foster and adoptive parents. I spoke then and met them. At that time, I had an open house at my home. My husband and I did once a month on Sundays for any foster or adoptive parent in the area that would like to come and network with other foster and adoptive parents. We had trainings, and the children were also invited. The Barahonas did come to my home on several occasions without children. This was prior to having children placed in their home. Roughly 2000, 99 and 2000. I spoke with them very frequently after the placement of their children via telephone. They did not come to the meetings as frequently due to the fact that the children were placed in their home and they tended to be busy at that point, which was very normal for a lot of my foster parents, especially my new ones. When I got to know them, I did find out that George was a pest control man. And at the point of approximately 2005, my husband and I were looking for someone, so we called Mr. Barahona to come to our home to be our pest control man. For approximately 2 years, almost 3 years, he came to our home every month. We became friends. We talked about issues being a foster parent, issues on how to adopt, general issues that I would talk to any of my foster parents or adoptive parents about. When the abuse allegations came up in 2007, I was asked by Kids Hope to go to their home as the foster parent liaison. I had been to their home several times previously as Trudy, as a friend, as another foster parent, delivered gifts, took them tickets to different outings. I had been in their home approximately 3 times prior to this, as they had been in my home prior to this. When I was asked to go for Kids Hope, I went into their home. I did not make an appointment. I showed up. I was allowed into their home. At that time, the only child that was there was Georgie. I had known him as a baby. I had remarked how well he was doing. I went into the kids' rooms. I saw all of their clothes. I saw how the rooms were laid out. I checked their pantry. I remarked that I was concerned about cameras. Why did they have cameras outside the home? And the logical reason that was given to me was because I'm a pest control man and I don't want anyone getting into anything that would harm them. Seemed logical to me. Yes, security cameras. Yes, they had a large fence around the front of their home. I honestly didn't think anything more of it. I talked with Carmen about the abuse reports. I had previously talked with George every month about abuse reports, about the issues of going to see Dr. Archer, about the children testifying, about the stress on the family. And they've asked me how to get through the system. My advice was, like it is to everyone, you go up the chain of command. I knew the children were from CFCE. I did not talk to CFCE, but I did give my report to Kids Hope that I found everything in the home to be as it was to be for foster children being placed in the home. I saw no allegations of abuse that would be substantiated. Based on my monthly visits with Mr. Barahona, as I said, we talked about the allegation. We talked about what to do. He told me the letters he wrote. He showed me letters he wrote. I was there as a sounding board for him. He did not ask me for any resources for the children. He just asked me how, as a family, they were to survive what they told me were allegations that were untrue. From my conversations with them, from my conversations on the phone with Carmen Barahona, I would have agreed that the allegations were untrue. From what my report was to Kids Hope, I did not find any indicators in the home that any of the allegations would be true. This was in 2006 and 2007. After 2007, the beginning of I could not give you specific dates.
Is that before or after the school reports?
This was after the school reports because he asked me how to handle getting through the school reports. And I told him, you document everything, and you sit back and answer the questions, go to the appointments you're asked to go to, and wait for a decision to be made. That's my advice to anyone who has an abuse report, and that's what I teach people. After 2007, 2008, I lost contact with them. I lost contact with them not necessarily for reasons of theirs, but for reasons of mine. I was overwhelmed with other issues, so they were not asking for any help, so I wasn't there for them. I received no calls from them, and Mr. Barahona no longer was my pest control man, so I did not see him on a monthly basis. I think, Mr. Lawrence, that honestly was for financial reasons. Like I think many people, if you have a problem, you get it resolved, and after it's resolved, you look at the finances and think, yeah, I could use that $30 someplace else during the month. As my husband and I do have 3 adopted children, so that was another use for money that we found. think, like many other people that met these families, found them committed to the children. I saw no signs in all of my years of having almost 300 children come into my home that my husband and I have cared for, having adopted children, having worked in the system. I saw no signs that anything horrible would happen to these children in this home. I've gone over it. I've thought about it. Everything I was told was logical in my mind. So where this came from, obviously I don't know. Would I have done anything differently, if that would be your next question? I'm not a foster parent any longer. I'm an adoptive parent. As an adoptive parent, I have some very strong beliefs that when we place children for adoption, we should do additional training. When children are adopted, we should be able to provide at least 6 months to a year of hands-on services for these children. We now have a hotline in place for adoptive parents, which I think is going to be a great service to these families. I think we need to place children a little better in specific homes. I don't think we should put special needs children in homes with other children that have special needs. I have 3. I think we have a lot of foster parents out there that have very big hearts, and sometimes we need to step back and think with our heads and not always with our hearts. Because once these children are out of the system and adopted, they're not part of the system. These children were community children, just like they were when they came into the system. And they're not. My personal opinion is an adopted child is always an adopted child. And we, as a system, need to be there to provide them services. And I think that's what our kids is now doing with putting this hotline, putting a newsletter out there, having an email database for our adoptive parents. This is a link that these people need. We go to court and we tell these people, please adopt our children and love them. We love our children. But we also have children with very special needs, and we need support. And I admire that Our Kids is doing that. And I wanted to let you all know that as an adoptive parent, I was appalled that the first report came out, when I saw it on the news of the pictures, that those children's birth names were used. Good or bad, my children are Petkoviches. Whatever they do, they are my children. And I would be appalled if ever one day a good story or a bad story brought in their birth names. And I hope that that can be addressed in some way through your panel here. Did you have any questions?
You mentioned in your recommendations about multiple children with special needs in the same home.
Yes.
But Trudy, you've in fact had multiple children with special needs in your home, not just 1 or 2.
You're right.
In fact, you're sort of a well-known and celebrated person for taking these children, but yet you're recommending now, if we have a child over here with autism, which we did, which we do, then to take another child probably isn't a smart idea?
I don't think it is. If I had known my first daughter was fetal alcohol spectrum disorder, I probably would not have taken my third daughter, who is mentally retarded. Because my first daughter's issues were so extreme that I never knew what we would have to handle. Now, I didn't know that. My second daughter was cocaine exposed. She's a straight A student. It's very hard to tell. But if we have diagnosed disabilities, I think we have an obligation to make sure that the parents we're putting these children with can handle these. My daughter, who is mentally retarded with an IQ of 55, is remarkable. And she's sweet, and she's loving, and she has no behavior problems. But she could. And if she did, that would be something I would hope somebody would say to me, do you know how to handle in case this happens? So I just would like to have a better screening when we place children with disabilities that we know.
Pete, does the department have a view on this?
Just in this last iteration of the contract with the community-based care agencies, post-adoption services were put in as one of the contractual requirements. Hadn't been there before. And certainly the issue, that's what Kathy Waters was talking about, of making sure you got a proper assessment of both the needs of the kids and the capacity of the parents, and that's a good match. That's right at the heart of what should be the process.
Yeah. Mr. Lawrence, when John and I adopted our children, there was John and I. And 6 years ago, he died. I still had 3 children to raise. Now, like you said, I know a lot of people. I know where to get services. I know whose door to bang on. That's why I'm so adamant about post-adoption services, because there's too many people out there that don't know. So if we could, at the front end, better educate them, and at the back end, make sure that there's services there and somebody for them to call is what I'd like to see.
Very helpful. Bob, you got anything? Great. Thank you, Judy. This has been... Pete, in the 10, 15 minutes we have left, how wise is to use this time?
Well, I think you wanted to make a statement.
Yes, sir. Ms. O'Leary?
I think Alan Michel said before that he is the attorney that was retained by one of our subcontractors, the Center for Family and Child Enrichment. And Alan has a short statement to make to the panel, which I've discussed it with my board, and we would endorse the concerns that he's going to raise.
Good morning. My name is Alan Michel. I am outside counsel for the Center for Family and Child Enrichment, which has served this community since 1977. CFCE, for short, is a provider for our kids. CFCE recognizes its obligation to cooperate with lawful and reasonable requests received from DCF. In this public forum, the panel is interested in asking fact-specific questions today of CFCE social workers concerning their work on the case through the children's adoption almost 2 years ago. The panel should already have the case records at its disposal. In the near future, but probably not by March 10th, CFCE is willing to meet privately and informally with panel members, assuming they are statutory agents of DCF, to help ensure a fair and balanced understanding of what actually occurred. DCF legal counsel will then need to advise the panel what may or may not be placed in the public domain. CFCE agrees that the public should not get its only explanations from the government. Unfortunately, however, the Florida legislature has forbidden child welfare agencies from furnishing unauthorized public testimony about dependency and adoption cases under these particular circumstances. The laws specifically are 39.0132, 39.00145, 39.202, 39.814, and 63.162. Similarly, in its HIPAA law, the federal government has prohibited unauthorized public disclosure of protected health information. HIPAA most assuredly applies to this case. We have serious reservations about this process beyond issues of confidentiality. We do not believe that the preset deadline is realistic. We also believe, any more than it would be in a criminal investigation, to say we need an outcome by a certain date. We also believe that the process being used to prepare a report will compel the independent panel to delegate much of its own fact-finding to DCF. Based on what we have seen so far of DCF's internal materials in connection with this matter, that would be a mistake. Therefore, and with all due respect and understanding the gravity of what brings us here, CFCE will provide public case-specific answers as soon as a proper order has been entered by a court of law compelling that. In the meantime, however, CFCE must decline to answer in an open forum the panel's case-specific questions. Thank you.
I just want you to know one thing.
Yes, sir.
So I know that I respect the fact that you're representing your client, but I want to make sure the public understands that. The Secretary of DCF reached out to me and my colleagues to my right, and he asked us to do this because he was concerned. And he made it very clear to us that what we were doing was preliminary, not definitive, and that from there would be further work done. And we've made it very clear that we're not going to do anything to impede the criminal investigations. So I think that what the Secretary asked for was admirable, and I think he should be lauded for it. He wasn't trying to trample on anybody's rights. I think part of your point may be well taken, and I've said this before. I think that this proceeding is too short in time to do anything more than just deal with the facts before us. So I would be reluctant to make any broad policy recommendations, regardless of what my own personal opinions are. And Mr. Lawrence and I have stated them publicly, generally about the well-being and education of children. But I am interested in facts, and so far there are some facts that have come out that I'm very concerned about. And I'll make those, I'll put that in the report to the Secretary. And it will be an incomplete report. It's apparent from the nature of this process that it's relatively abbreviated, so it will be incomplete. But I think the Secretary's intentions were laudable, and I think he intends for other steps to proceed and for other agencies and to take over thereafter.
I agree with everything you've just said, and I think that one of the problems structurally was needing to do this in the sunshine, plus having to abide by the child confidentiality laws and HIPAA, and I think there's a conflict.
There's a challenge. I've been dealing with the sunshine issues for over 20 years, and that's unique to our state, and on balance, I certainly am all in favor of it. We all know of its limitations, but that's the way he chose to conduct the proceedings, and that's what we're conducting.
Well, thank you for this opportunity to address our concerns.
Now, let me ask you this way.
Yes, sir.
You're not only representing your client, but your client. You're a citizen of this community with a wonderful reputation for caring about children.
Thank you, sir.
So what's your sense, without violating anyone's privacy, of what you understand of this case so far? What are your thoughts about where we could do better?
Well, Mr. Lawrence, I was retained yesterday. Okay, so I want to exhibit a little modesty. Okay? I know that may be not common, but I think... well put. I know Miss Petcher. I know Trudy. I've known Trudy for years. I've been to her home when she was in South Dade. I think the world of Trudy. I think she's a woman of great judgment. I think also we're looking to try and how to improve the system. I represent a number of people who've adopted through the system. And we sometimes wind up getting in an adversarial relationship with the department as to getting the services we feel they're entitled to. I think beefing up post-adoption services, looking prospectively, would be a very good programmatic improvement. How it impacts the particular facts of this case, I'm not in a position to say at this point. And I also think that, the inability of some people to come here because of their position, such as a judge, to speak on their own behalf, I think may give the public, as avidly interested as they are in getting to the bottom of this, a skewed perception of what actually occurs on a day-to-day basis and what the drivers are for conduct that occurs.
All points well taken in your way. You can't look at things that
But if you would like CFC personnel to meet with you in private, and assuming we can get a representation that you're agents of DCF, so we are not violating the law, because we don't think the ends justify the means, we'd be more than happy to sit down with you and discuss our thoughts and views on what happened in this case. And then DCF can decide how much of that should be made public. Okay? Thank you, gentlemen.
Pete, I think we we'd like to get some guidance on exactly what he is talking about. Because frankly, we'd like to know as much as possible, as early as possible. I think this, some of you know I chaired the Aurelia Wilson panel, which went on for months. And I do think some good things came out of it. I believe what Bob says, which is the secretary, when I talked with him, felt very strongly we need to move swiftly and understood it was a very preliminary sort of probe. And that I think we have the absolute ability in our recommendations to say, and you need to look at this and this as well. But if there is, I for one am not wedded to March 10th and 11th. Though I think this being done with all deliberative speed would be fully understandable and important. But if it meant another week that we could get the sort of information that Alan is talking about, I think it would be very useful. So we hear the testimony from Christy this morning, and I sort through things in my own head. Then I hear Trudy Petrovich, somebody who did testify and was very helpful at the Aurelia Wilson hearing, which I think was 7 years ago or 8 years ago. Somebody I've admired for years, and she says, well, I was in that home a whole bunch of times, and I didn't see this stuff. And was as shocked as anyone else about what happened here. So I'd love to know our kids provider and what those folks think. I'd like to get it in any way possible.
I'm going to talk to Javier and to Mary as soon as we're done here about the possibility of just getting a court order that would ease any concerns people have. And I think the schools have a similar concern. Is that correct? Schools here? I guess they're not.
So let's make that an absolute priority in all of this. What I'm going to propose is that we cut it off here for today. Go ahead.
Again, I just want to deal with the facts, and I don't really want to. I don't want this panel to be a review process for the DCF. I don't want to expand the mandate. And March 10th may be fine. March 17th on the outside. I don't want us to become a super panel and be empowered with expertise and powers beyond what we're really capable of doing, let alone everything else going on. So I caution doing that. But the Dr. Archer report that was given to us, am I allowed to quote from it?
May I volunteer an opinion?
No, actually, I want you to sit down for a second.
Javier, talk about the HIPAA.
I would say that with regards to Dr. Archer's report, the HIPAA issues that predominate, I would ask that we do not go into any details. You can make general comments about it, general conditions, but I would not go into any medical.
This is going actually into the summary of findings of background information.
Background information, if it's something that we've talked about already, that's already been put out today.
I don't think this is a HIPAA problem. Here's what he says.
Well, then I'll defer.
She's dead.
The summary of findings sheet, it says background information. Quote, while both children were in special educational classes, they are excelling academically, close quote. Now, I'd like to know what the source of that information is. We're hearing, to me, dealing with concrete facts presented to me, we have a clash here between the concrete information delivered by the schools and then the failure to pick up on it. So I'd like to know more about why that ball was dropped. Very specific. I'm not looking for. I will let Carol Miller and Errol and others for another day look at the macro picture. I just want to know about the facts of this case. And then following up on the schools, I think schools play a very important role here. It's my understanding that after 2010, the kids were taken out of the school system and put into homeschool. And talked a little bit about this before. I believe that there are some requirements in homeschooling, that it can't just be done, on your own, and there would be to impose some requirements on the parents. Now, I think by that point in time, the children were already adopted. Right? So DCF's role was out of it, but nevertheless, there is a role for the state to play. So I'd like to know how it was that these children were taken out of the school system at a time when there were a lot of red flags and allowed to be homeschooled, and what was the follow-up to make sure that they were compliant with what the law requires of homeschooling for children. Again, I want to be, I think in the limited amount of time, Pete, that we're empowered to do this, I want to just deal with the facts that are made available to me.
So let me add some things, Pete. At the next session, in a brisk way, let's go back to Jackie Collier and Fran Allega as to their recommendations in a bulleted sort of way. Would like to hear from the school system about all of this. We'd like to wrestle to the ground the question of the legal wherewithal to get the information we need. I think we still want to aim for the end of next week. So let's stay on that course, and if we decide after Thursday of this week that doesn't look possible, we'll call it on the fly then. Okay?
Got it.
Is there any public comment? Thank you very much. We're adjourned.
Hey, Sam. I've been, my phone's been trying to find it. Okay.
Lopez, how are you? How are you? Good.
Christine, C-H-R-R-I-S-T-I-N.